9,
Recording in progress.
10 to 18.
Pardon to mention item 13.
Adjournment.
Permitted to withdraw, my lord.
Kindly give your memo.
Yes, my lord. I will file this.
Kagaz de diyantu.
Yes, sir.
2 p.m.
Yes, sir.
Oh. You have informed the other side?
Yes, sir. I
Yes.
also submitted the document that I had filed through email.
Yes. You can come at 2.
Yes.
Yes.
May I
Or
please?
say 2:15 like that. 2. Yes, Mr. Lanka.
My lord, the order passed by the learned Judge Fulbani, Family Court Fulbani, allowing the petition under section 125 CRPC filed by the present opposite parties or petitioners is under challenge before Lordship. My lord, here is a case where, my lord, the objection or Lordship have a glance filed by the petitioner before the learned trial court.
First you take me to the plaint.
Yes.
Because it is not your case, it is her opposite party's case.
Yes, my lord. The case is that the marriage was solemnized on 21st June 2021.
So what are the grounds one can, husband can't deny?
The ground, my lord, in fact, I have also given the judgment, the documents to the effect that in fact she had married to somebody.
Sir, that's not that. That cannot be taken up in 125. You have taken the stand that she is not your wife.
Yes, sir.
Not your wife. So what was the evidence before the learned trial court?
Trial court, my lord, the annexure 4, that is the judgment.
Judgment
In another case, in a criminal case that was initiated by the wife against her first husband.
So where you have confronted in your cross-examining her? Because it's not a Supreme Court or High Court decision. Please appreciate.
No, that
exhibit markers, exhibit A.
exhibit A.
Because a lady can marry 2 times, 3 times after, say, theoretically, suppose she gets divorced, she gets separated.
Yes.
Or annulment of marriage. So she can marry for the second time.
So
And during the second marriage, she claims 125. So
Yes.
that can be a possibility also. So have you confronted this to the lady to deny that she is not your wife?
That
This is a revision, Mr.
yes, sir, that I have conscious, my lord. That is the
Para 20 of Justice, Honorable Justice Deepak Mishra's judgment.
evidence. I have collected the evidence.
The collection of evidence, collection is a matter of investigation.
No, I will file.
Appraisal, no, not here. Not here. Can you look at this?
So or your lordship a call for the LCR.
No, that is not my job. I am not serving the husband who is not adducing evidence. I am dispensing justice here.
No, that's true, my lord.
So you have to be very simple. You have to check the pleadings and the depositions. That's it. You can do better than me, Mr. Lanka. I am more than confident. By checking the pleadings and evidence, you can do better than me. Kindly look at this. Just have a look at glance at this. I am not passing any order, but why I say so that there is a point. Para 20, just look at para 20. If you can read it aloud, sir, because I have one copy only. Just kindly read it aloud.
In the instance case, as it's seen, the High Court has reduced the amount of maintenance from 4,000 to 2,000. As it is manifest, the High Court has become oblivious of the fact that she has to stay. Needless to say, the order of the Honorable Family Judge is not manifestly perverse. There is nothing possessible with which would show that order is a sanctuary of error. In fact, when the order is based on the proper appreciation of evidence on record, no revisional court should have interfered with the region of the on the basis that it would have been arrived at a different or another conclusion. When the substantial justice has done, there is no reason to interfere.
That much.
Yes.
So even if I think that some different conclusion could have been made,
Yes.
and the language is, what my lord Justice Deepak Mishra writes.
Yes.
That is, but English is. And then another by Justice Gupta, Justice Aniruddha Bose, just read this para too.
We are constrained to observe that this order showed the total non-application mind on the part of the High Court. This was a case where the maintenance had been granted to a wife and to a minor son. The High Court, without recording any reason whatsoever, has stayed the grant of maintenance, both the wife and to the minor son. This should not be the. Yes, so that.
So the problem is, unless I arrive, suppose I appraise, according to you, suppose I consider your evidence.
Yes, sir.
Hamima Faruqi says that even if I arrive at a different conclusion, I cannot, because it's a revisional jurisdiction. The scope is very limited. The problem, Mr. Lenka, is that maybe there is a good evidence, but they did not adduce. They did not adduce the evidence.
That's right.
So that can't be a second innings. So it is only a kind of trial is only one innings. Only, sir, this much, because of the unwillingness of the person to pay. This much I can do that from the date the court has directed, you pay till today, I will issue notice. That much I can do, so that I don't invite this wrath of the language used by the Honorable Apex Court. Total non-application of mind will be argued. If they read this judgment, they will argue, tell me that.
For a moment, Lord, we have just.
No, what is on record, I have to.
No,
so kindly refer to that. I have the petition.
No, that is not there.
So then if it is not there,
evidence is not there. The evidence is not there. That is why the
evidence you have to examine, and you have to raise those grounds. Then I have to examine applying Samima Faruqi. That whether based on the evidence the judgment is correct, or I can go on. I can pass an order in revision. The revisional court has its limited jurisdiction.
the only much she was.
Child is there.
Yes, child is there.
Still much. Then it is almost, because maintenance of child in 125.
But
The section itself defines.
here the case.
Mr. Lenka, you must understand, I cannot pass a value judgment. According to you, then it's a illegitimate child or not your child. 125 takes care of that.
No, that
Children, wife, illegitimate child, the language is used is illegitimate child. And here you may dispute the paternity also, but that is your Child Evidence Act. During subsistence of a marriage, the presumption is that you are fathered the child.
she was confronted only to the extent that at her instance, a criminal case is pending against her first husband. Her husband.
That makes out. That case is neither here nor there. That may be a counterproductive for you. So you are aware that she was married. Still, you have married her. You see, the jurisprudence has evolved in domestic violence, any relationship. Even 125 also, there are decisions. Check Rajneesh versus Neha. They have enlisted all the decisions.
No, his evidence to the extent that after coming to know that she is there is no husband-wife relationship.
Then the problem is, then you should have got a declaratory relief. Sometimes Sometimes
That-
declaratory relief is necessary.
Yes, well,
But 125, the court is tired. Court cannot go into beyond what is there on record and say that if 498 is allowed, then perhaps there is no marriage. Those kind of latitude is not given to a magistrate in 125.
yes, sir.
That's not there.
Notice,
You take instruction.
notice जाओ.
Sir, without I cannot. If you say file affidavit that you will deposit, then I can or you deposit the money that I have suggested you, so
That
that
I-
I have a leeway not to face the wrath of the court. And today everything is reported in media. Actually, we are into a generation, Mr. Lenka. It is no more AIR, SEC, OLR. It is all in the public domain. So you must understand what we are doing. So you take that instruction.
Next week ଗୋଟେ ଦିନ ଆସୁ.
Say any day, sir. So you can take time, but that will be beneficial for the person to arrange money. Because
The execution case is posted to
that is the reason he has come to you.
tomorrow. That
If I pass any order, I will send it to the executing court. I have a reason for adjourning it. Whenever I am passing an order, I am sending to the executing court. The executing court, after seeing that the High Court has not interfered, will pass orders.
that's why
In many cases, they are not honoring. In a Jashpur matter yesterday, it was argued at length because the learned counsel, I had to engage amicus. He has furnished that non-compliance, and for 88,000, he went for a 1 month civil imprisonment. That they are doing. So that is so they are hell-bent. The civil court has dropped the proceeding. The learned family judge has dropped the proceeding because beyond that, it cannot do anything. Property list, she cannot furnish. Suppose she has not. In that case, she did not furnish the property list for seizure or auction.
another procedural irregularities
And
here in the
execution, Rahul's Supreme Court has directed it has to be disposed of at the earliest. Again, they are tired. The courts have some kind of limitations in handling these matters, and you should have the correct approach should have been that any order should have been sought for in the court if a properly constituted petition is filed, declaratory relief. Yes. Then there is a possibility. Otherwise,
ଆଉ ଟିକେ ଆସନ୍ତୁ.
ଆପଣଙ୍କର problem hochi, you should ask these questions that at this stage, how you will address the court regarding the circumstances of the marriage. And there is a child and she is the wife. If she disputes the marriage, then who will do that? So he has to. ଦେଖନ୍ତୁ whatever amount କେବେଠୁ ସେ ଦେଇଛନ୍ତି, କେତେ amount total ଅଛି, କେତେ ସେ ଦେଇପାରିବେ, all those instructions you can update. The learned counsel for the appearance like Mr. Niranjan Lenka for the petitioner, opposite party blank. The learned counsel for the petitioner was had at some length. The petitioner, husband in the marriage, has filed the application, filed the revision application, seeking to set aside, seeking a direction for setting aside the judgment dated 14.05.2025 passed by the Lord Judge Family Court Fulbari. That's Kandhamar. They are tribal. Are they tribal?
Tribal.
That's another difficulty. That is the accepted norm. The accepted norm. Polyandry and polygamy is accepted. That is how Hindu Marriage Act has also said that excluded. Their personal law permits that.
Why?
Anyway, that's a bigger issue. Or likely? Passed by the so and so District Land Judge Family Court Fulbari, CRP number 48 of 2024. The said CRP was filed by the petitioner wife in the marriage along with minor child aged about 2 years, represented through his mother, guardian. Or sentence of product. That's fine. Yes, seeking a maintenance of
10,000.
10,000
10,000.
for the wife and 5,000 for the child. The CRP came to be allowed. Directing a payment of rupees 3,000 to the wife and pilau kishi deinahanti.
Each.
3,000 each to the wife and the child, that is 6,000 per month from the date of filing of the application. On date of filing application, comma 06.05.2024. The petitioner remains in default in complying the said direction. In considered opinion of this court, no, not in considered, it's a decide. The lauded Judge Family Court has for rendering the judgment has relied on the oral evidence of the 3 PWs, 2 OPWs, 3 documents filed on behalf of the petitioners, and 11 documents filed on behalf of the opposite party petitioner herein. The lauded counsel for the petitioner has adjournment to obtain instruction regarding how the petitioner will secure the decree, which is in the nature of a money decree. Secure the secure the direction for payment of monthly maintenance, which is in the nature of a money decree, as directed by the apex court in Rajneesh versus Neha. List in the week commencing. କେବେ ଆଣିଲେ ହେଇପାରିବ
23rd ଅଛନ୍ତି
23 the week commencing 23/2/2026. Yes,
Item 2,
Mr. Alok Kumar Mohanty, Senior Panel Counsel, Mr. Mohanty, Senior Panel Counsel for the petitioner. You are challenging Lok Adalat order. So you have gone through Jalor Singh and
Yes.
Bhargavi.
yes
Yes, so kindly look at Jalor Singh, which is the guideline by the Supreme Court.
madam. That is paragraph 12.
Paragraph 12 of General Singh.
Yes, my lord. That has been dealt with the last in case of Bhargavi construction, your lordship. That is dealt with. That is 2000.
General Singh, Bhargavi says you have not read read para 33 of Bhargavi. ଆପଣ ଏଇଟା କରିବେ ଆଉ ଭାର୍ଗବୀ ଯୋଉ ଅଛନ୍ତି 33 ପଢନ୍ତୁ କାଇଣ୍ଡଲି ରିଡ୍ ସାର୍ ବାଁ ପଟରେ ଅଛି ଆପଣ ଡାହାଣ ପଟେ କେମିତି ଦେଖୁଛନ୍ତି ଆପଣ ଗୋଟେ ପଟେ ଧଳା ବେଶୀ କାଗଜ ଗୁଡା କାହିଁକି ଗୋଟେ ବୋଥ ସାଇଡ୍ ପ୍ରିଣ୍ଟ କରିବ ସବୁବେଳେ ଓଜନ ବି କମିବ କାଗଜ ବି ନଷ୍ଟ ହବ so far as
this is my paragraph 33 your lordship.
ଆଜ୍ଞା
This is very issue.
ନାଇଁ ମିଶୁନି କୋଉଟା ଧରିଛି କଣ ଆପଣ ପ୍ରିଣ୍ଟ କଣ ଇଣ୍ଡିଆନ କାନୁନ
ଏଟା ଆଜ୍ଞା
ଠିକ ଅଛି ସେ ପାରାଗ୍ରାଫ ଟା ପୂର୍ବ ପଢିଲେ କଣ ନାଇଁ ଆପଣଙ୍କର ଗୋଟେ ପାରାଗ୍ରାଫ ଆରମ୍ଭ ହଉଛି ଦେଖନ୍ତୁ so far as the second submission ତାହେଲେ ମତେ ଦିଅନ୍ତୁ ମୁଁ କାଢିଦେବି ମତେ ସାରଙ୍କ ବହିଟା ନିଏ ମିଶୁନି let us not waste time ମାଇକ୍ରୋଫୋନ ଟା ଟିକେ ଆଡଜଷ୍ଟ କରିଦିଅନ୍ତୁ ହଁ ଏଇଟା 37 ଆପଣଙ୍କର ସେଇଟା ଅପରେଟିଭ ପୋର୍ସନ ଟା ତ ସମାନ ନା 37 ଦିଅନ୍ତୁ
And so far as the second submission of land counsel for the respondent is concerned, it also has no merit. In our view, the decision rendered in the case State of Punjab Supra is by the larger bench, 3 judges, and is therefore binding on us. No efforts were made and likely to contend that the said decision needs consideration.
Reconsideration, na?
Reconsideration on the issue in question. That apart, when this court has laid down a particular remedy to follow for challenging the award of Lok Adalat, then in our view, the same is required to be followed by the litigant in letter and spirit as provided therein for adjudication of his grievance in the first instance. The reason being that it is a law of the land under Article 141 of Constitution of India. That's one so. It is It is then for the Merit Court to decide as to what orders need to be passed on the facts arising in the case. In the light of foregoing discussion, we cannot conclude.
This actually binds us. So whatever is there, that procedure you have to follow in Jalursi. Maybe a format of affidavit, or because the reason is very simple, Mr. Mahanti. It is easy to visualize also. For disposal in a Lok Adalat, lot of effort is made. People are invited, courts spend their time, officers are invited, there is a lot of deliberation, pre-conciliation, pre-Lok Adalat, sittings, all that. Thereafter, everything is done, parties agree, they put their signature. Then if there is a challenge, and the law is well settled, you can challenge 227. But the grounds and the procedure, as in State of Punjab, what you have read. So you examine that. If you are not ready to that way, you just examine that. Otherwise, it becomes what? Because we can't discuss every day the same thing. Time is we are consuming. So straight away you come to how you have satisfied Jalur Singh. That is what I told you.
Jalur Singh, in this instant case, in my case, my lord.
Sir, I appreciate your concern and approach. But please let us go by the law.
My lord.
You straight away go to Jalur Singh and show that you have followed Jalur Singh.
Your lordship kindly permitted to read the 12 of the paragraph 12.
33 ଟା ପଢିବନି
39 ମୁଁ ସେଟା ରିପ୍ଲେଟ୍ କରିଛନ୍ତି
12 ଟା ଡିସ୍କସନ
ମାଇ ଲର୍ଡ
ଆପଣ ଯଦି ଯେମିତି କହିବେ ଯେ ଟୋଟାଲ ନନ୍ ଆପ୍ଲିକେସନ ମାଇଣ୍ଡ ବାଇ ଦ ହାଇ କୋର୍ଟ ସେମିତି କାଇଁ ମତେ କରାଉଛନ୍ତି ମୁଁ 33 ପଢିବିନି 12 ପଢିବି
no
ସେଟା ଆଇ ୱିଲ୍ ଗो ଆଡଜୁଡିକେଟିଂ ସୋ ସେମିତି କାଇଁ କରୁଛନ୍ତି ମୁଁ ତ ସେଥିପାଇଁ ଆପଣ 33 ବାହାର କରି 37 ଆପଣଙ୍କର ବାହାର କରିକି ଦେଲି ପଢୁନାହାନ୍ତି ପଢନ୍ତୁ ଆପଣ କୋଉଟା ପଢୁଛନ୍ତି କୋଉଥିରେ କୋଉଟା ଭାର୍ଗବୀ ପଢୁଛନ୍ତି ନା ଜଲର ପଢୁଛନ୍ତି
Right now.
12 ଯୋଉଟା କହୁଛନ୍ତି କୋଉଟା ପଢୁଛନ୍ତି
12 by the Jalor. That has been
କଣ ପାରାଗ୍ରାଫ ମିଶୁନି କଣ ପଢନ୍ତୁ କଣ ଲେଖା ହେଇଛି
paragraph 12. It is true that where an award is made by the Lok Adalat in terms of a settlement arrived at between the parties, which is duly signed by the parties and annexed to the award of Lok Adalat, it becomes final and binding on the parties to the settlement and becomes executable as if it is a decree of civil court and no appeal lies against it in any court. If any party wants to challenge such an award based on settlement, it can be done only by filing a petition under Article 226 or Article 227 Constitution. That too on very limited grounds. But where no compromise or settlement is signed by the parties and the order of Lok Adalat does not refer to any settlement but directs the respondent to either make payment if it agrees to the order or approves the High Court for disposal of appeal on merits. If it does not agree, is not an award of Lok Adalat, the question of challenging such an order in a petition under Article 227 does not arise. As already noticed, in such a situation, the High Court ought to have heard and disposed of the appeal on merits. To that effect, Lordship, then Lordship, I may be permitted.
so what is your I mean what turns on that what is your submission on it by reading para 12 what is your submission
That has been, Lordship, that has been dealt with the final opinion given by the, in case of Bhargavi constructions.
अरे आपण भार्गवी 33 भार्गवी कहले भार्गवी 2 judge bench भार्गवी says follow Jalor Singh 3 judge bench
Mela.
so if you now say take a different view from Jalor Singh then there is a problem for you Bhargavi doesn't say so
Well, just a issue.
my lord मत कहले कोन भैया lords are decided
I may be permitted to read the issue, Lordship.
three lords and two lords say that it is 3 lords that will prevail because there is no plea for reconsideration of 3 judge bench अब मु कोन करिवे एतरे
ଟିକେ ମୁଁ just
ଆପଣ ତ ଟିକେ ଆଜ୍ଞା ସେଗୁলো ଗୋଟେ ଚଲେଇଛନ୍ତି ଏବେ ବି ଆପଣ ପ୍ରାୟ କରିଛି ଆପଣ କଣ ଚାହୁଁଛନ୍ତି 12 କୁ କେମିତି ଫଲୋ 12 ଯଦି ଆପଣ ରିଲାଏ କରୁଛନ୍ତି how you feel what is the what terms and 12 ଆପଣଙ୍କ କେସ ରେ
ମୋ କେସରେ ଆଜ୍ଞା ହୋଇଛି ଯେ you last occasion you put the question to me whether the
question କୁ ଯାଆନ୍ତୁ today we have
Yes, yes.
same thing that whether you have read Jalor Singh now you say that I have read Jalor Singh and Bhargavi
whether my case
that can Bhargavi says follow Jalor which is the larger bench decision State of Punjab versus
Yes,
State
yes.
of Punjab not
Yes,
Jalor
yes.
Singh State of Punjab versus Jalor Singh
Yeah. In my case is that the authority has passed awarded without giving consent. The party has not given consent. That has been passed on merit, my lord.
when you file appeal 12
Yes, that party is right.
so how 227 is maintainable
To that you take, your lordship, right to pronouncement judgment.
Who is that cannot be argument can we reread 12 again slowly that is how I don't know how much time we will take for this
Yes, my lord. In my
सिला स्टेट पढନ୍ତୁ but where ଉପରୁ 5-6 ଲାଇନ ଛାଡି ଦିଅନ୍ତୁ 7 ଲାଇନ ଛାଡି ଦିଅନ୍ତୁ then but where no compromise
But where no compromise or settlement is signed by the parties and the order of Lok Adalat does not refer to any settlement but directs the respondent to either make payment if it agrees to the order or approves the High Court for disposal appeal on merits. If it does not agree, it not an award of Lok Adalat. The question of challenging such an order in petition order Article 227 does not arise.
Kindly stop there. I am precisely doing that, sir, asking you, sir, I am sitting in 227. Read with 226 also.
Also,
So Supreme Court has said that you challenge in appeal. So you challenge in appeal. If you are relying on para 12, and as you have said, that there is no consent from you.
in my, yes.
So challenge in appeal.
Either give liberty or file of
Sir, what liberty I can give, sir?
other because my lawyer, unless until give the liberty.
No, if, sir, suppose I do not know even whether the appeal is barred by time. So even if barred by time, pendency of the writ can the other court, appellate court, it will be a FAO.
FAO.
FAO before the district judge is not maintainable. ମୁଁ ଆପଣଙ୍କୁ ପଚାରୁଛି ସାର୍ ଆପଣ ସବୁ କଥାରେ ହଁ ମାରନ୍ତୁନି I am also educated.
Here is
They are in the trial court before the district judge is there. Suppose civil judge, senior division, FA is maintainable district judge. So I am asking you if here you are filing the appeal before the district judge or before the high court.
here in the present case, ये case jealousy case in my law, that matter relating to the motor accident claim. So FOI is filed.
So it need not be motor accident. The question is different. So the simple is that you want to challenge
Yes.
by on the ground that I'll record this with Mr. Mahanta. Record this that there is no consent.
That's for I may be permitted. It's for lots
Kindly, sir.
Yes, yes.
Sir, first of all, when you say that to ask me to follow Bhargavi in contradiction to Punjab,
My lord.
I cannot because Bhargavi said Punjab prevails.
That is true. Well, they have
So kindly read that.
yes, sir. Paragraph, your lordship, I am reading that. 27. In our consideration view, the approach law laid down by this court is binding on all the courts in the country by virtue of mandate Article 141 of the Constitution. This court is no uncertain terms.
Not in this court in no uncertain terms.
This court in no uncertain terms has laid down that challenge to the award Lok Adalat can be done only by filing a writ petition under Article 226 or Article 227 Constitution of India in the High Court, and that too on very limited grounds. Then 20th paragraph, let's see. In the light
छाड़ देले कितने हो सर पूराटा पढ़िबे सर
I can say that.
selective reading always creates very too much of confusion and you discuss case law.
Then related to the 27, 28. In the light of clear pronouncement of the law by this court, we are of the opinion that the only remedy available to the aggrieved person, respondent herein or plaintiff, was to file a writ petition under Article 226 or 227 Constitution of India in the High Court for challenging the award dated so and so passed by the Lok Adalat. It was then for the writ court to decide as to whether any ground was made out by the writ petitioners for quashing the award, and if so, whether those grounds are sufficient for its quashing.
ଆପଣ ଏଟା ଜଲୋର ସିଂ ପଢୁଛନ୍ତି ନା ଭାର୍ଗବୀ ପଢୁଛନ୍ତି
Bhargavi finding.
ଭାର୍ଗବୀର କେତେ ପାରା ପଢୁଛନ୍ତି
Bhargavi, my lord, 27 and 28.
ତାପରେ ସରିଗଲା judgment ନା ନାଇଁ ଅଛି
Last finding ଦେଲେ
ଆପଣଙ୍କର 37 ଯଦି ପଢିବେନି ଭାର୍ଗବୀରେ then I have to reject your contention. ଆପଣ ଯଦି ଆପଣଙ୍କ 37 ମୋର ସେଟା actually SEC standard text ରେ ଅଛି 33 37 ଆଉଥରେ ପଢନ୍ତୁ.
So far as the second submission of counsel for the respondent concerned, it also has no merit. In our view, the decision rendered in the case state of Punjab Supra is by the larger bench and is therefore binding on us. No efforts were made and rightly to contend that the said decision needs reconsideration on the issue in question. That apart, when this court has laid down a particular remedy to follow the challenge award of Lok Adalat, then in our view, the same is required to be followed by litigant in letter and spirit as provided therein for adjudication of the grievance in the first instance. The reason being that it is law of the land under Article 141 Constitution of India. It is then for the writ court to decide as to
141 ପରେ full stop ଅଛି ତ ଛାଡି ମିଶେଇ ଦେଲେ ତା ଦେହରେ ବର୍ତ୍ତମାନ ଆପଣ Bhargavi says state of Punjab the litigant has to follow. Now you take state of Punjab para 12 ଯୋଟା ପଢୁଥିଲେ ଏବେ
my lord. It is true that award is made by the Lok Adalat in terms of a settlement arrived at between the parties, which is duly signed by the parties and annexed to the award of the Lok Adalat. It becomes final and binding on the parties to the settlement and becomes executable as if it is a decree of civil court, and no appeal lies against it to any court. If any party wants to challenge the such an award based on settlement, it can be done only by filing a petition under Article 226 or Article 227 Constitution of India. That too on very limited grounds. But
Then read slowly, which now we are reading for the third time. But where
compromise or settlement is signed by the parties, and the order of Lok Adalat does not refer to any settlement, but directs the respondent to either make payment if it agrees to the order or approach the High Court for disposal appeal on merits. If it does not agree, is not an award of the Lok Adalat. The question of challenging such an order in a petition under Article 227 does not arise.
So, if you read Bhargavi and Punjab together, they have made clear-cut distinction. Either it is a Lok Adalat award or it is not a Lok Adalat award. For Lok Adalat award, you agree, sign. Not Lok Adalat award, you do not sign.
Sign.
That is your case here.
Yes.
So it is covered, squarely covered by Bhargavi and Bhargavi takes care of it also. Bhargavi 37 in your... But what is the source of that print? Supreme Court website.
Supreme Court of yeah.
Judgment by Supreme Court. Kouthu asila seta. Printer kouthu bahar kale.
Printer mo net etu mobile leke katil pa seta.
Semti korantuni. I have a little experience in that. In Chief Court, senior advocate came from Supreme Court. He was arguing a 61 Supreme Court.
Hello.
I simply stood up. He placed a paragraph. I said that, let's see.
Alert.
ଆପଣ ଯେତେ ପକେଇକି ରଖିବେ ଆପଣ appeal ଫାଇଲ କରିବେନି.
That's it.
ଆପଣଙ୍କର ଏ କେସ୍ ପୁରୁଣା ହେଇକିରି ଆର ଆପଣ ଦିଥର କହିଲେନି. And now I think you are convinced yourself.
ଗୋଟେ ଚାନ୍ସ
ଲାଭ କଣ ହବ? ଆପଣ ଯେପର୍ଯ୍ୟନ୍ତ appeal ଟା ଫାଇଲ କରିବେନି, you will be in trouble.
ଗୋଟେ Monday
ନାଇଁ Monday କଥା ନାହିଁ. Monday ମାନେ I mean real depth of time ହେଇଯିବ ଫେରେ. We have already ଯେତିକି ଆପଣ discuss address କଲେଣି ଯେତିକି discussion ହେଲାଣି, it is a full-fledged judgment now. It has to be. Lok Kumar Mahanti लिखिଛନ୍ତି. Lok Kumar Mahanti, Senior Panel Counsel for the petitioner. It is submitted by the पूर्ण order किछि अछि.
Maybe another decision would mean that is 2025 SEC online. Supreme Court.
ଆପଣ ତ ଠିକ ରେ ପଢୁନାହାନ୍ତି.
Just have got it. ନାହିଁ.
ସେଟା କଣ ହବ?
ଯଦି
Bhargavi is the latest. All of you are relying on Bhargavi. Bhargavi follows Punjab. So no difficulty there. He submitted that the learned Lok Adalat, before the learned Lok Adalat, the petitioner did not give consent for passing of the award. The learned counsel relies on, senior panel counsel relies on Bhargavi construction versus Purada Likhiwe versus Kotha Kapu.
versus
Kotha Kapu.
Kotapu Muthiam.
Dita Bindu Deki into bracket 2018 13 SCC 480. Paragraph 12. So the relied upon paragraph 12. Paragraph 12 आउथरे पढिले भार्गवीर कोनटा भार्गवी रिलाय करछन काना आपण पारा मो पारा मिसुनी पण भार्गवीटा एससीसी ना कोठ आणछंदी
सेटा हम कहले सेटा नेट रू माने जणा
ठीक अछि पैराग्राफ टा कोन रे पढिले मु जानि परिबी
सेटा आगे भार्गवी रे पैराग्राफ पढली आगे सेटा 27
नहीं पढंतु सर पढि देले मु जानि जे ठीक तो ठीक नहीं
in our consideration view the appropriate law laid down by
just 1 second in our considered view
my lord That is ending thing.
But mate diyantu. I have to find it out.
I marked it.
এটা ঠিক নেই. Don't rely on this. সেটা ଆପଣଙ୍କର এটা ବିଲକୁଲ ମିଶୁନି. I didn't know that, but I was just told you that I narrated that event, incident. Don't do this. In a considered view, ତାପରେ ପଢନ୍ତୁ.
In a considered view, the appropriate law laid down by this court is binding on all the courts in the country by virtue of mandate of Article 141 of the Constitution. This court, in no uncertain terms, has laid down that challenge to the hour of Lok Adalat can be done only by filing a
ସେଟା ଆପଣଙ୍କର ମିଶୁନି. Always refer to the book. No, I don't get prints where
paragraph.
paragraph 12 ଲେଖନ୍ତୁ. Related the କାଟି ଦିଅନ୍ତୁ. Paragraph 33. At paragraph 33 of the of Vargoli construction, the following has been observed by the Hon'Ble Apex Court. Into bracket लिखिबे SCC online web edition print. ହେଲା. At paragraph 12 of the three-judge bench rendered in State of Punjab and another versus JALOUR Singh and others. The following has been laid down. The following has been observed. The following has been observed. Safety bracket लिखिए SCC online print, web edition print. Paragraph 12 तक कर देले. The Lord Counsel seeks further adjournment. Lord Senior Panel Counsel seeks further adjournment. Accordingly, the matter is adjourned to be taken up in the week commencing. ପୂର୍ବରୁ କେବେ ଲିଷ୍ଟ ହେଇଥିଲା ଆମର ହିୟରିଂ ହେଇଥିଲା?
3 ତାରିଖ
ଡେଟ୍ କହିପାରିବେ?
3/2 ରେ.
କଣ ଲିଷ୍ଟ କମେନ୍ସିଂ ଡେଟ୍ କୁହନ୍ତୁ, କେବେ ଚାହୁଁଛନ୍ତି?
10th.
ସେ ୱିକ୍ କରି ରଖୁଛନ୍ତି. ୱିକ୍ କମେନ୍ସିଂ 9th ହେଇପାରିବ? we commencing 9/3 9/2
No,
ଆଜି କେତେ ତାରିଖ ହେଲା କି?
ଆଜି 5 ତାରିଖ।
23/2 ରଖନ୍ତୁ ଆପଣ ତ ମୁଁ ଆକ୍ଚୁଆଲି ମାର୍ଚ୍ଚ ଆଉ ଫେବୃଆରୀରେ କନଫ୍ୟୁଜନ ହଉଛି। ଫେବୃଆରୀ ଆଜି ଫେବୃଆରୀ 6 5 ନହେଲେ ଆପଣ ସିଓର ତ କନଫିଡେଣ୍ଟ ତ ପୁରା 1 crore ହେଲେ ଲକ୍ କରିଦେବେ ନା କଣ? ଆପଣ ତ 3 ତାରିଖରୁ ଆଟଲିଷ୍ଟ ଟୁଡେ ୟୁ ସିମ୍ ଟୁ ବି ଭେରି କନଫିଡେଣ୍ଟ ଆଣ୍ଡ convinced by reading both but ଆପଣ ସେ
ସେଇଟା ମୁଁ ଆଜ୍ଞା
no that has confused you. Those paragraphs paragraphs not in serially.
ବହିଟା
So you kindly look at the book so that is how I was unable to understand how the conclusion is different.
ଆଜ୍ଞା conclusion.
So there is some problem there. Some page is missing or something, I don't know. The week commencing 23 na nor kebe apan chahunchu.
Because I am hurry because education case time jati time doguna the attachment order रहेगा. That is the problem also.
Nor rakhuntu, I have no difficulty. We
We
commencing
come 9th of 9th.
9 ठीक है 9 February 2. But you have not filed that. I remember that you told me execution is filed, so that is how I said that unless you file appeal, that will be difficult. Because you are saying appeal, I am saying appeal, but you are adjourning. Your contention is that also. Today you read that you have not given any consent. So
Yes,
appeal is a remedy.
that is my case. I mean,
You have not given consent. ठीक है, we comment कर दो. The first line जो लिखी है, the earlier the matter was had at some length on 3/2/2026 पर. Yes.
Item 3,
My lord, the petitioner is the husband. But 2 proceedings are there. The opposite party wife filed one criminal proceeding under section 144 of BNSS. And the husband filed one CP 117/24 before the Learned Judge Family Court, Nayagarh. Lord, the petitioner filed application before the court below that since the CP is pending, that is prayer was made like this. There is no marriage between the petitioner and opposite party, and the opposite party is not the wife of the petitioner, and other reliefs. And here's the wife claimed for maintenance. Their petition was filed for that you kindly postpone the hearing till the maturity decided by the civil court. That was rejected, therefore he filed Lord's one criminal miscase. That you Lordship kindly see page 17.
Criminal miscase filed in which petition, sir? Actually, that we could not find out. Mr. Nayak was in VC.
That
He did not know. So, criminal miscase was filed challenging which order?
This order. Refusal that the
Refusal for adjournment.
Yes.
So it has been adjourned.
Then
Now the court directed for adjournment.
Yes. In spite of that, you see the court.
Then sir, I do not have jurisdiction.
Let's.
The court which has taken up that criminal miscase, you have Annexure 3.
Yes.
The court that has passed order, not Annexure 3, it has Annexure. Order कोड़े वाला.
Page 17 देखो.
So अलगा अलगा सेटा आउ गोटे पेज रे हां 17 रे annex mark हेनी. हां हमर भूल हिच. So suppose this order passed by the bench, which is exercising jurisdiction in CRLMC. So that court has to be taken.
Look, that didn't follow your lordship's order.
No, I cannot direct Mr. Mahanti. I cannot direct the court to follow the coordinate bench's order. That's the coordinate bench. I am not the judge.
Lord, that's true.
Your point is well taken.
Yes.
That despite the order passed dated 27/10/2025 by the coordinate bench in CRLMC, the matter is not adjourned.
Adjourned cost was also imposed.
So that could be communication gap. What reason I cannot say, of course, or you will be knowing the reason. But that court has to be moved. We cannot exercise parallel
The
jurisdiction.
court is out of the way and passing an order in
What
spite
can
of
be done, sir? You have to file this CRLMC 3733 is pending before the coordinate bench. So that this move, I mean, you may not withdraw this now because you are seeking transfer of that 125 piece.
Because the ground is she will not
Correct.
get.
125 upon transfer maybe, but transfer as the stay of the adjournment is concerned, it is already granted in
No, because-
3733.
Lords, the fact is, because the learned court below did not adjourn in spite of Lordship's order,
Correct.
and went on imposing cost day after Lord's other.
So that court has to be moved. That court is available also.
Court is not Lords, didn't access the.
That cannot be a ground to transfer a matter.
Lords, then I say he will not get injustice there. Therefore,
Could be, but first you, I mean, move the court which is having jurisdiction on CRLMC.
that one aspect, other aspect
But
becomes.
that day perhaps Mr. Naik did not brief you that way because Naik was also not sure which matter he is moving. Because
This is the matter. This is matter.
This is the matter. This is a TRPC.
My lords.
There are two cases. One is CRLMC and one other is TRPC. TRPC is filed seeking transfer. The CRLMC challenging the order, not adjourning the matter. So that adjournment issue is already in the court in session of the matter.
Lords, what I beg to submit is the grievance of the petitioner that since the court did not obey the order of the higher forum.
That is my grievance also.
Yes.
That
So-
is my grievance also that I cannot.
So see,
Like the learned judge family court not following High Court judge's order. One High Court judge
Like-
not looking at other High Court judge's order.
can I presume that High Court is a remedy? Lords, High Court.
So in the same case, I will supervise my. So in the same case, I will supervise my. The coordinate bench of High Court and supervise also the district judge.
Lords,
That's it.
jurisdiction different. That is a separate aspect.
That
This
is the
also
problem.
total-
So I do not have the jurisdiction.
Lords,
Either I am taking up Mr. Mohanty. You see, and it is not difficult also. The CRLP is pending. The petitioner has already moved the court and got an order of adjournment. You see, that is now the order of adjournment is by the High Court.
No, Lords. Adjournment is not the concern. Concern
You are not
is
getting it, sir.
Lords,
So kindly look at the order of passed by the Lorded coordinate bench. The coordinate bench.
page 17.
Yes.
Page
As an interim
17.
measure, kindly read that.
Lords,
Para 5.
as an interim measure, it is directed that on an application being filed by the petitioner seeking adjournment in criminal MP number so and so, the learned court in
So also no, sir. That is important. So 14 of 2024.
24, yes.
Yes.
114 of 24, the learned court in session over the matter shall do well to adjourn the matter for a period of 4 weeks.
Now kindly look at the prayer here.
Plus,
Para page 7. Just that petition, page 7.
para 7.
Page 7, I'm so sorry.
Page.
Prayer, caption, paragraph, prayer. Page 7.
Therefore, petitioner humbly begs prays that this honorable court may graciously please to issue rule nisi to opposite party to show cause as to why criminal proceeding 114-24 annexure 1 shall not be transferred from the file of the learned judge family court Nayagarh to the file of learned judge family
So
court.
there 145, section 145 of BNSS is a bar. Now already there is an interim order. So you must appreciate that.
No, that's true.
I cannot be oblivious. You have stated in the petition also that despite the interim order passed by the bench taking CRLMP, the court has not adjourned, imposed cost. So that order should be shown to that court. You must understand that. And it is very simple. Because if you move the court that the order is there and you do so then simply adjourn this. Let there not be conflicting orders.
Lord, the court is insisting for taking up the matter, therefore that
Then I cannot direct the other court to take up the matter.
Lord, that's true.
No,
But
no,
whatever
that
is
should not be.
supposing your lordship passes
Sir, here this is a problem created by the petitioner himself. He has moved simultaneously to different jurisdictions. One, the fast movement has resulted in an interim order.
not the same jurisdiction.
That's the problem.
That-
Yes, you are answering the same thing. I cannot exercise CRLMP
This
jurisdiction.
is with regard to transfer,
Transfer.
that she is
No,
not.
so let it lie over. I'm not saying that this is not maintainable. I'm saying that to pass an interim order when there is already an interim order, that's the problem. And it is on face of it, the court has said in clear word, though it's an adjournment, but it is for 4 weeks. So you should have moved.
Case before reaching the case, lordship, before your lordship can see the date and thereafter.
So whatever you move that court, you move the
Even
bench.
the date is expired. Your lordship knows because before in profession, your lordship reading very research oriented and also doing that. Your lordship kindly. Lordship,
Sir,
said when the matter is sub judice before a higher forum, the subordinate could at least restrain herself or himself to proceed with the matter because the matter
That point is, Mr. Mohanty, is well taken. I told you from the beginning.
yes.
But when the matter is sub judice before higher forum in the same court, two different judges, one court has passed interim order. The second court can it supervise?
Lord, two different jurisdictions.
Correct.
Two different forums and two different separate.
But it has a sequence. The order has a sequence. That order is already there, passed by the coordinate bench.
That is
And all judges, let us assume, Mr. Mohanty, that even it is all judges are equal or not.
equal.
Then
You will say assume the jurisdiction.
No.
This is the case of
I will assign Sierra Olympic. It is just possible that the same court could be. Possible.
Lord say,
So why from that date the Sierra Olympic is not moved? I also do not understand.
Lord say, what I beg
Because you are not the counsel there, I think.
no, I am the
So
I am the-
why
I am the
Mr. Naik is late for marriage? He said that I'm busy in some marriage. So Mr. Mohanty will address.
Lord brother, I requested you to
So correct. So why? In fact, that day when I asked that why this order is there, why he could not say anything.
Your lordship, this is a case of transfer. That is the lordship. We have
Sierra Olympic obtained this interim order. So that I'll simply observe and adjourn this. Had Mr. Mohanty allotted counsel at length. The appearance likely, Mr. Amir Kumar Mohanty for the petitioner, opposite party blank. I'll take some time, Mr. Mohanty, just sit down. Is there any difficulty? I'll let you know. Ask you. The petitioner husband in the marriage has approached this court under section 447 of Bharatiya Nagarika Suraksha Samhita, 2023. Seeking transfer of CRL.M. C capital, RL small, dot short form, CRL.M.P. case number 114 of 2024. From the court of judge, family court, Noyagara, to the judge, family court, Khurda. As it is stated in the cause title of the petition, also stated by the learned counsel for the petitioner that CRL MC number 3733 of 2025 is pending adjudication before this court, though in a different context, that is challenging an interim order passed by the learned judge, family court. The CRLMP was filed under section U/S 144 of Bharatiya Nagarika Suraksha Samhita BNSS, 2023 by the petitioner wife in the marriage seeking maintenance. The learned coordinate bench, the coordinate bench by order dated 27.10.2025 had taken up the serial MC number 3733 of 2025 and IN number 2493 of 2025 and passed the following interim order. Paragraph 5 ta quote kar debe, page 17 re achi. Para. In view of the fact that the coordinate bench is already in season of the matter and has passed interim orders. The petitioner shall have the liberty to move the said court as he has challenged the interim order. ତାର କଷ୍ଟ ଟାଇଟଲଟା ନାହିଁ ବୋଧେ ସେ ଅର୍ଡରଟା କେତେ କହିପାରିବେ ସେୟାର ଏମ୍ପିରେ ଯୋଉ ଅର୍ଡରଟା ଚ୍ୟାଲେଞ୍ଜ ହେଇଛି ଡେଟ୍
ଏଇଟା ସାର୍ ଦେଖନ୍ତୁ ମୁଁ ଗୋଟେ ଦେଇଛି ୱେବସାଇଟ ର ହାଇକୋର୍ଟ ର ଗୋଟେ ଦେଇଛି ସେଥିରେ ଅଛି।
ନାଇଁ ସେଇଟା ସେମାନେ ତ ଏଣ୍ଟ୍ରି କରୁଛନ୍ତି ଏଣ୍ଟ୍ରି ଭୁଲଭାଲ ହେଇଯାଉଛି।
ନାଇଁ ଏଇଟା ଯୋଉ ସତର ଦେଇଛନ୍ତି ଠିକ ଦେ ପ୍ରମାଣ ତ ନାହିଁ କରିଛନ୍ତି।
ନାଇଁ ଅର୍ଡର ଡେଟଟା କେତେ ଆପଣ ଯୋଉ ଅର୍ଡର ସେ ରିଫ୍ୟୁଜ କଲେ ସେଟାକୁ ଚ୍ୟାଲେଞ୍ଜ କଲେ
ହଁ ଓ ଯୋଉ ସେଇ ଅର୍ଡର
ହଁ ହଁ ହାଇକୋର୍ଟ order I have mentioned the date also case number also ସେ ପିଟିସନରେ ସେଟା ଆନେକ୍ସ ହେଇଥିବ। ଠିକ ଅଛି but the case is pending anyhow କଣ ଲେଖିଲେ next time yeah passed in the serial AP number 14 of 2024 refusing to grant adjournment. Para. Yes. ନୟାଗଡ଼ରୁ ଚାହୁଁଛନ୍ତି ଖୋର୍ଦ୍ଧା. The present application seeking transfer of the serial MP number 114 of 2024 is adjourned. Liberty to mention.
सर 6टा होची से सिविल प्रोसीडिंग आइटम 6टा होची सिविल प्रोसीडिंग से ट्रांसफर
माने सीपीटा पर हस्बैंड फाइल करछन्ते निजे
हां
बट निजे फाइल करछन निजे ट्रांसफर चाहुछन
प्रिहेंड करछन जे सेठी यू विल नॉट गेट एन जस्टिस देयर देयरफॉर शी वांट्स टू ट्रांसफर बिकॉज़ शी इज नॉट
तेरे अर्जन थाओ आपनकर जदी सेठी अर्जनमेंट जोटा 4 वीक्स हेतला जदी एक्सटेंड हे गला ताले सीपी रे से ग्राउंड इज वेरी डिफिकल्ट द जस्टिस पाइबेनी बोली केमपी कोन करिवे तो सिंपली अर्जन थाओ सेथिरे आपनकर बतन कंसर्न हला जे 114 टा आपनको अर्जनमेंट बोलुनी कॉस्ट इम्पोज होउची तो ऑलरेडी देयर इज ऑर्डर यस मिस्टर अमिय कुमार महांती फॉर द पिटिशनर the petitioner husband in the marriage has approached this court under section 24 of the Code of Civil Procedure 1908 seeking transfer of CP number 179 of 2024 filed by the petitioner before the Lorded Judge Family Court Nayagad to the Lorded Judge Family Court Bhubaneswar. Today, a connected matter that is the TRP CRL 13 of 2026. Seeking transfer of CRL MP number 114/2024 filed by the wife in the marriage seeking maintenance under section 144 of BNSS 2023 has been adjourned. So accordingly, the present application is also adjourned. Liberty to mention.
Item 4.
Lords, husband's petition before my lord.
এটা অর্ডার যোটা নেক্সট অর্ডারটা আইটম 6 ଏବେ ଯୋଉଟା ଆପଣଙ୍କୁ ଡାକୁନଥିଲି କି 3 ପରେ 6 ହେଇଗଲା ତ so don't miss the ଇଏ then at item 4 now Mr. Abhilash Mishra for the petitioner. Yes, Mr. Mishra.
My lord, the judgment dated 28 and 2020 passed by the judge family court under annexure 6 is impugned, wherein the petitioner is directed to pay monthly maintenance of rupees 4,000 as well as lordship, that is page 57, my lord.
Yes, 4,000.
4,000 to the wife and 2,500 to the child.
Yes.
And the my lord
You want enhancement or decrease?
decrease.
Because in some cases,
But my lord,
so instead of 25,000, 6,500 has been awarded.
my lord,
Grounds of challenge.
lots of challenge, my lord, is that my income is 11,081 rupees.
Where what evidence?
Evidence is not there, my lord. But what happened, my lord?
Then if there is evidence, I have already I have referred. You were present.
Yes, yes.
Observations of honorable.
What happened? The petitioner prepared an application for divorce under section 13. The wife appeared and filed an application under section 24 of the Hindu Marriage Act. That was allowed. Lordship, kindly have a glance that order, my lord.
Sir, then again you are arguing against yourself. If there is an order in section 24 granting maintenance pendental light
My lord.
in 125, have you brought to the notice of the court that this much I have paid or I am
Yes,
paying?
that has been set up. That has been set up, adjusted. That has been adjusted.
Then
My lord,
if it is adjusted, so that is how, because
My lord.
yes,
the court below observed that my income is 11,081 rupees. But since my expenditure is mentioned more than 20,000 rupees, awarded, lordship, awarded a system.
Correct.
And my lord, till that the
So if you spend 50,000 and say that I do not earn anything, out of that 50,000, as per High Court decisions, 2-3 decisions are there. 25%, 50,000 of the amount you are spending, 25% you can spend for your family.
my lord.
And there is a minor child.
And my lord, I'm paying the maintenance.
And this is a revision. Revision, very little scope for interference.
My lord, the observation that, my lord, that the same family judge, my lord, while allowing the application filed under section 24.
Same family judge, but both the matters were taken up together.
No.
Then,
But my lord, same fact, same.
sir, same facts, there is no concept. Then you have to rely on some provision in the law. There is
Lordship, kindly have a glance.
So it cannot be res judicata. 125, section 24,
No,
if
no, my lord.
only set off is allowed. So
Yes.
don't argue that. So don't argue a point which will be, rejected,
My lord,
on the face of it. Suppose you argue this. The same judge took up both the matter, same set of facts, but arrived at a different conclusion, or it is not different, it is similar conclusion. But appraisal of evidence is different. It has to go, your contention has to be rejected. There is no such concept.
my lord.
24, suppose 1,000 is awarded. 125, he is awarding 5,000. Then if he does not calculate 1,000, deduct 5,000 to 4,000,
That has been done, my lord. That has been done.
then it is. So because that is the mandate of Supreme Court.
Yes, my
decision.
lord. Rajesh Neya.
Yes.
Overlapping jurisdiction.
So because 125 is magistrate.
My lord.
Supreme Court has said, since all petitions have to be taken over, domestic violence is also magistrate.
Yes.
So magisterial inquiry power has been conferred on the Superior Court.
My lord.
And 24 magistrate cannot exercise. Please that also appreciate that. If you say same judge, it's in a different context altogether. The contours are different. The judge is not exactly acting as a magistrate.
But my lord, my income is 11,000.
Sir, the problem is that you are spending 50,000.
And my lord,
Somebody is saying that I am a pauper, he has to be a pauper in true sense. Lack of capacity to spend money.
in my pleadings, I have mentioned that I am a daily wage laborer, my lord. That has not been taken.
Sir, what you have proved?
Only, my lord,
You have to cross-examine. You have to cross-examine
no,
the other side.
there is no cross-examination.
No evidence, sir. RPF.
And there is no pleadings to that extent.
That is how, with some little bit interacting with all of you, I have tried to understand the law. Just now, if I was discussing, because opening the day I try to,
Yes.
I
was present, man.
so then you know,
But in the totally,
different conclusion cannot, suppose what you are arguing will lead to a different conclusion by the revisional court.
Well,
but not permitted. I cannot, I cannot superimpose my different conclusion on the conclusion of the trial court, which has been arrived after proper appreciation of evidence.
but it is the fact that
So if you want issuance of notice, that setup amount already set up.
already that amount I'm paying.
Cannot.
That amount I'm paying, my lord.
Otherwise, you could have, produced here that I have paid this much, all these things. So whatever is directed till they appear, that will continue to pay. You
Well,
put that instruction?
I'm paying that earlier amount which I directed in 24.
This 125, because I am interfering in 125.
Well, the
Besides for interference, if you require, you want issuance of notice,
Yes.
same principle. You obtain instruction, let him deposit till they appear at least, because it's a monthly, it's not a lump sum,
my lord.
it's a monthly. What is how much is directed? 6,500.
6,500.
So 6,500 from the date of application.
From the application.
Date of application is
My lord, that is 4/10/23.
1423. So 2 years.
My lord.
25 ମାସ ହେଲେ ଆପଣଙ୍କର 1.5 ଲକ୍ଷ ଟଙ୍କା ହେଉଛି 25,150.
My lord. All deposit, my lord.
Instruction ନିଅନ୍ତୁ, because they will not listen to you. The
Right.
problem is that they don't listen and the case drags on. The learned counsel for the petitioner was heard at length. Oh, डाकिची. अच्छा, डाकिनी, sorry. The petitioner, you just take your seat. I'll take some time, 2-3 minutes. I have to dictate this. The petitioner husband is before this court seeking revision of the order dated the judgment dated 28/10/2025. The petitioner कौन लिख रहा है? Purchase passed by the learned judge, family court. Palaso. Order date after डाकिए. नहीं. Order dated 24/24 ଆପଣ 24/24 ଠିକ ଅଛି ତ?
No, my lord. 28/10.
ତାହେଲେ ମୁଁ ଆଉ ଗୋଟେ ବ୍ରିଫ୍ ଧରିଛି ବୋଧେ.
24/24 the order passed by in IA, that is under 2024. That is
ଆପଣ ପ୍ରେୟାରରେ କୋଉଟା ଲେଖିଛନ୍ତି? 28/10/25 Annexure 3 ମିଶୁନି. ଆପଣଙ୍କର ଇମ୍ପ୍ରୁଭଡ୍ ଆନେକ୍ସର ଟା କେତେ?
Annexure 6, my lord.
The co-method. Dev Prakash Panda is the ଆପଣଙ୍କର Dev Prakash Panda ତ ରଞ୍ଜିତ କୁମାର ବର୍ଦ୍ଧନ.
Yes, my lord.
Can you look at page 9?
Yes, that is mistake. Annexure 6 instead of Annexure 6. It is but
ତାହେଲେ ଫାର୍ଷ୍ଟ ଲାଇନ୍ ଲେଖନ୍ତୁ. It is submitted by the learned counsel for the petitioner that inadvertent typographical error has crept into the ସବୁଠି ଲେଖିଛନ୍ତି annexure 3 ନା କେବଳ ପ୍ରେୟାରରେ annexure 3 ଲେଖିଦେଲେ?
only prayer.
ଚେକ୍ କରନ୍ତୁ.
No, only prayer.
Inadvertent typographical error has crept into the paragraph captioned as prayer. Quote ରହିବ. Stop. The impugned annexure has been mentioned in the prayer paragraph as annexure 3, whereas it should be annexure 5, annexure 6.
My lord.
Stop. The learned counsel seeks leave to correct, to carry out. Seeks leave to carry out necessary correction in the prayer portion of the petition. File that they carry to prayer portion of the petition. Leave granted. The learned counsel shall carry out the necessary correction in the prayer portion of the petition. He shall bear his signature to be countersigned by the court master. Page 9 को करंतु. Mr. Barik, page 9 देखंतु. Page 9 रे first paragraph रे annexure 3 लिखा है. दियो से पेज टा दियो. हैला. तापर एटा लिखले. कौन लिखले? Baleshwar in criminal proceeding number 351 of 2023. Stop. The said petition was filed by the wife in the marriage and the minor child represented through his mother. Under section 125 of CRPC, claiming maintenance at the rate of rupees 15,000 for the wife and rupees 10,000 for the son. The learned judge has allowed the learned judge family court Balasore has allowed the petition. However, directing rupees 4,000 as maintenance for the mother and 2,500 for the child. Mr. Mishra, how they will survive with this amount? You know the cost of living, and for a growing up child who is now in class 7, the education expenses.
That has been exhibited.
Even far better, 10,000 is allowed. Here it is 2,500. The application is before High Court that he will read in international school. So that is the extreme case. But this is the minimal approach of a court. And for this, you do not require any affidavit also.
And all the school.
And if you multiply the daily wage, as you have stated, what is the daily wage now? 600.
Skilled 600.
Wow.
It is.
Oh, wow. If you are employed by an official, they will pay you 400 or something. But private employment, you can ask anyone.
600.
It was 600 2 years back. So if you are it cuts both ways. Either you are employed with the High Court employing, it is 300 or something per day. Total 12,000. Outsourcing person who you see. If you are privately engaged, the presumption is that you are earning at least 600. And out of that, 1/3 he has only given you. Anyway.
But
that instruction. I am not passing that order today. For the child. After the Lord Counsel for the petitioner has completed his arguments, he has adjournment to obtain instruction how the petitioner will secure the grant of monthly maintenance, which is in the nature of a money decree. Into bracket, Rajneesh versus Neha. Para list in the week commencing? 23/2/2026. Yes, next please. Sorry, ଆପଣ ଡାକୁନାହାନ୍ତି Mr. Dharanidhar Naik, senior advocate, along with Miss A. Misra. Miss A. Misra for the petitioner. Yes, please.
It's a case, my lord, where the petitioner is the husband.
Yes.
A case was instituted against him by the wife in the family court of Kota. In the family court of Parampu, claiming for maintenance because she is not staying. So for paying up maintenance, she has filed a case for maintenance, my lord. And without taking into account my income, my expenditure, everything, my lord, an ex parte order of maintenance was passed in the favor of the wife.
By which order you have set ex parte?
My lord, Annexure 1.
Order dated?
26/4/2019. That was subsequent. You lots may hearing me for
No. If now the issue is, since it is ex parte order, I have to look at the ex parte order when you were set ex parte. Then what happened thereafter? Have you
Yes.
challenged the ex parte order?
Yes, but
Setting
I
aside-
have challenged the expert order in the High Court. The High Court directed me, my lord, to file a petition there. It was set aside, subject to payment of a cost of rupees 30,000. And thereafter, my lord, I paid the cost in terms of this demand draft in the court itself.
So you are allowed to participate.
I was allowed to participate.
Correct.
That set aside, my lord, that expert order was set aside. I was allowed to participate.
Recalled. Set aside by the High Court or
By that court.
High Court recalled.
High Court
It has to be recalled.
Yes, ma'am.
High Court directed that you approach the court. Courts imposed a condition, or High Court directed 30,000.
No. That court, lower court.
30,000 who imposed?
Lower court, my lord.
When you move the lower court, so lower court recalled the order.
My lord. Subject to
So you are sorry, and you are satisfied.
Yes, ma'am.
The condition you are satisfied, and now you participated in the proceeding.
No, there's some problem. This 30,000, my lord, I was satisfied with the amount. I did not challenge that order in the High Court. That 30,000 cost was imposed. Didn't challenge that. I paid 30,000 in terms of a demand draft in the court. That order was set aside. Thereafter, my lord, I was directed to participate in the proceeding. Thereafter, what happened, my lord? After some days, after this order was set aside,
Set aside, why you are saying? By which order? Why the court has used the language of setting aside?
Yes.
Its own order.
Yes.
Okay.
After this order was set aside, my lord,
Set aside by the same court.
Same
The appellate court.
same court. Okay. Subject to payment of a cost of rupees 30.
My little learning is that it should be recalled. I cannot set aside my order.
Yes.
Like you were discussing with Mr. Mahanti, can he set aside
As your lordship.
Yes. Okay, but he has used the language as that is what you are saying.
Difference
Yes.
between use of language, but this is the purpose is, my lord, that set aside or record whatever it may be.
Date. When did you pay the cost? Order date? Recording payment of cost.
And my lord, 12/11/24. Annex of
Page.
my lord, 44.
44. 44 is 44. 44.
Yes, my lord.
44, yes. 12/11/24.
My lord. My lord, the case record is put up today for payment of the cost of rupee to the OP wife, and for further orders, OP wife is present with her learned counsels in obedience to the order dated.
So he has used the language of setting aside ex parte decree like a civil proceeding. Okay. If you read the ex parte judgment, so and so is set aside and restored to the original file.
Yes.
Yes, is disposed of.
Yes.
So your petition is allowed.
Yes.
Yes, DD acknowledgement she has received. Then what happened?
Thereafter, my lord, I paid the cost of this 30,000 in terms of.
It is already there, sir. Page 44 shows that 30,000 is recording, DD number, acknowledgement, everything is there.
ସବୁ ହେଇ ସାରିଲା ପରେ ଆଜ୍ଞା ସବୁ ହେଇ ସାରିଲା ପରେ ତାପରେ କେତେ ଦିନ ପରେ ତାପରେ after 10 months she again my wife again came to the court and said that I am finding some difficulties in encashing this demand draft. Therefore, my husband should be directed to pay me cash instead of this demand draft. That is after about 10 months. So I was, my lord, after 10 months, my lord, then I took some time, my lord, because I have already prepared the demand draft. So I took some time for payment, my lord. Since there was a delay in payment, thereafter, my lord, the same court, again set aside his own order.
Kindly mark the order, page 46, 5925. You have received the demand draft.
Yes, my wife has received.
Demand draft is dated 24/10/24. Expiry date is 24/1/25.
Again.
So you receive it on 5/5/9/25.
Again. Not received. I have paid.
5/1/25. You receive it on 5/9/25.
Relative telling us that electrical issues ଅଛି 5/9/25 ରେ
5/9/25 ଅର୍ଡରଟା ଆଜ୍ଞା ସେ ଆମକୁ ଫେରେଇଲା ସେଦିନ
Right? ସେ ଆପଣ ନେଲେ ତାପରେ କଣ ହେଲା?
ନେଇ ସାରିଲା ପରେ ସେ ଆମକୁ କହିଲେ କ୍ୟାସ୍ ଦିଅ ଆମେ କ୍ୟାସ୍ ଦେବାରେ ଡେରି ହେଲା ବୋଲି ସେ ପୁଣି
କେବେ?
Annexure 7 ମାଇଲ
Page 48.
Yes.
28/11/25.
ଆଜ୍ଞା a long order, page 51, your lordship may kindly see the last para. The purpose of
It is better to read the entire thing because the facts are complicated.
the opposite party granted the husband to pay the cost of rupee 30,000 are hereby closed. The non-payment of the cost within the stipulated time, which is wrong, my lord, and even thereafter, despite,
Yeah, that's not wrong. That is correct.
correct, my
You are
lord.
not marking the dates actually.
ଆମେ ଟଙ୍କା ଆମେ
Sir, ଆପଣଙ୍କ ପାଖରେ ଟଙ୍କାଟା ଆପଣ ବ୍ୟାଙ୍କ କୁ ଦେଲେ
ଆଜ୍ଞା
ବ୍ୟାଙ୍କ ଆପଣଙ୍କୁ ଡ୍ରାଫ୍ଟ ଦେଲା
ଆଜ୍ଞା
ଡ୍ରାଫ୍ଟ ଟଙ୍କାଟା ବ୍ୟାଙ୍କ ପାଖରେ ରହିଲା
ଆମେ ଆଣି ଡ୍ରାଫ୍ଟ ଦେଲୁ କୋର୍ଟରେ ଦେଲୁ
କୋର୍ଟରେ ଦେଲେ
ହଁ।
ନାଇଁ allow me to complete so that you will understand. ଡ୍ରାଫ୍ଟଟା ଆପଣଙ୍କୁ ଫେରା ହେଲା ଆପଣ ନେଇକି ଗଲେ
ଆଜ୍ଞା
5/9
ଆଜ୍ଞା
ତାପରେ ଏ ପ୍ରୋବ୍ଲେମ ଆରାଇଜ କଲା ଆପଣ ଡ୍ରାଫ୍ଟ ନେଲା ପରେ ବ୍ୟାଙ୍କରୁ ଟଙ୍କାଟା ଆଣିବା କଥା କାରଣ ଡ୍ରାଫ୍ଟଟା କେବେ ହେଲେ ଏନକ୍ୟାଶ ହେଇନି ଯଦି ଏନକ୍ୟାଶ ହେଇଥାନ୍ତା ଦେନ୍ what you are saying is correct. ତାଙ୍କର ଆକାଉଣ୍ଟ ନଥିବ ମୋଷ୍ଟ ଲାଇକଲି ଆଇ ଡୁ ନଟ୍ ନୋ ହ୍ୱାଟ ଇଜ ଦ ରିଜନ ଡ୍ରାଫ୍ଟ ତ ଡିପୋଜିଟ କଲେ ଆକାଉଣ୍ଟ ଥିଲେ ହେଇଯିବ ବଟ୍ ସମ୍ ରିଜନ
ଆଜ୍ଞା
ପଇସା ତ ଆପଣଙ୍କ ପାଖରେ ରହିଲା ନା
ଆଜ୍ଞା
ହଁ ଆପଣ ବ୍ୟାଙ୍କରେ ଦେଲେ ଡ୍ରାଫ୍ଟଟା
ଆଜ୍ଞା
ବ୍ୟାଙ୍କ ଦେଲେ ବ୍ୟାଙ୍କ ଆପଣଙ୍କୁ ପଇସା ଦେଇଥାନ୍ତା
ଛୋଟ କଥା ଟିକେ ମୁଁ ତାଙ୍କୁ କ୍ୟାସ୍ ଦେଇଦେବା ପାଇଁ ଚାହିଁଲି ସେ କହିଲେ
ସେଇଟାକୁ ଆପଣ କରିଦିଅନ୍ତୁ ଇନଫ୍ୟାକ୍ଟ ଆପଣ ଦେଖନ୍ତୁ
କ୍ୟାସ୍
46 ରେ 46 ଦେଖନ୍ତୁ
ଗୋଟେ ସେକେଣ୍ଡ ସାର୍
ଆପଣ ନ ଦେଖିଲେ ପ୍ରୋବ୍ଲେମ ହବ
କୋଉଟା
ପେଜ 46 ଦେଖନ୍ତୁ ମାର୍ଜିନ ଦେଖନ୍ତୁ ଟପ୍ ରାଇଟ୍ ମାର୍ଜିନ ଆପଣ ରିସିଭ୍ କରିଛନ୍ତି ହ୍ୟାଣ୍ଡ ରିଟିନ୍ ଆପଣଙ୍କ ସିଗ୍ନେଚର ଅଛି
ହଁ ଡ୍ରାଫ୍ଟ ନେଇଗଲୁ ପରା
ଆପଣ ତାକୁ ଡ୍ରାଫ୍ଟ ଆପଣ ତାକୁ ଯୋଉ ଦେଇଥିଲୁ ସେ କହୁଛନ୍ତି ସେଇଟା ହବନି କାରଣ ଆଇ କ୍ୟାନଟ୍ ରେକର୍ଡ ଦ୍ୟାଟ୍
ନା ମୁଁ କହୁନି
ସୋ 5/9/25 ପରେ
ଆଜ୍ଞା
ସୋ ଏଇ ଅର୍ଡରଟା ପାସ୍ ହେଇଛି ଆପଣଙ୍କର 28/11/25
ଆଜ୍ଞା
ଅଢେଇ ମାସ ପରେ
ଅଢେଇ ମାସ ପରେ
ସୋ ଅଢେଇ ମାସ ଆପଣ ଆପଣଙ୍କ ଡ୍ରାଫ୍ଟ ଆପଣଙ୍କ ବ୍ୟାଙ୍କର ଆପଣ ଡ୍ରାଫ୍ଟଟା ରଖିଲେ ଡ୍ରାଫ୍ଟଟାକୁ ନେଇକି ଦେଇଥିଲେ ପଇସା ନେଇ ଆସିଥାନ୍ତେ what reason why cannot say so then what happened ସେଇଟାକୁ
ସେଟା ଆମେ ବର୍ତ୍ତମାନ କ୍ୟାସ୍ ଆଜ୍ଞା ଦେଇଦେବୁ କହୁଛୁ ସେ କ୍ୟାସ୍ ଦେଇନୁ ବୋଲି ସେ ତାକୁ ନିଜ ସେଟା ସାଇଡ୍ ଯୋଉଟା କରିଥିଲେ ସେ ଅର୍ଡରଟାକୁ ଆଗେନ୍ ହି ସେଟା ସାଇଡ୍ ହୁଇଚ୍ ହାଜ୍ ନୋ ଜୁରିସଡିକ୍ସନ କହିଲେ ସେଟା ପୁଣି ସେ ହିୟରିଂ ହବ ସେଟାକୁ ସେ ଆଗେନ୍ ହି ସେଟା ସାଇଡ୍ ଦି ଅର୍ଡର by which he has set aside the expired order. He has allowed me to participate, my lord, subject to payment of rupees 30,000 cost. Your lordship may issue a notice. I will pay him 30,000 here, my lord.
28 ଟା ପୁରା ପଢନ୍ତୁ କଣ ଲେଖା ହେଇଛି 28 ଟା ପେଜ 48 ରେ ପଢନ୍ତୁ
This order appertains to the petition dated 26/9/25 and 17/10/25. The opposite party by petition dated 17/10/25 has appeared to expunge the remarks highlighted in the petitions from the order dated 22/10/25. On the other hand, in this petition dated
22/10 ଟା ନାହିଁ ତା ଦେହରେ actually ଆପଣଙ୍କ brief ରେ ଏବେ ନାହିଁ anyway ଆପଣ further ପଢନ୍ତୁ
the prayer to another 26/9 the OP has a prayer another 1 month adjournment to comply the order of this court regarding the payment of a cost imposed upon the while setting aside the expired order. The prayer in both the
so what is this Mr. Naik you received your draft after 2.5 months bank is your draft is yours and you are seeking 1 month
okay
it takes a 1 day it will not take a day ଆପଣ ଯୋଉ ଡ୍ରାଫ୍ଟ ଯଦି ଚେକ୍ ହେଇଥାନ୍ତା ଗୋଟେ କଥା ଆପଣଙ୍କର ବାଲାନ୍ସ ନାହିଁ ବ୍ୟାଙ୍କ ତ ଟଙ୍କା ଆପଣଠୁ ନେଇଗଲା ଆପଣ ଡ୍ରାଫ୍ଟଟା ନେଲେ ମାର୍କ ଦ ଏଣ୍ଡୋର୍ସମେଣ୍ଟ ଅଲସୋ ୟୁ ହାଭ୍ ରିସିଭ୍ଡ go to the bank and get it
he has some negligence he should have paid your lordship he should have paid your lordship
what is that I mean who told him to do all these things I don't understand
that's
maybe he did not pay the fees to the lawyer
this is the lower court
once I visited the trial courts
all that happened in the all that
everyone was coming because there is a because they are not meeting the lawyers and it happens throughout India I mean not because
that is in the lower court that happens in the lower court I am not concerned. This only problem is, my lord, I will pay him in the court itself here, my lord. Or
you pay there, sir.
Your lordship,
sir, you have been given sufficient time also. Sir, a draft you receive.
I completely agree with your lordship. I completely agree with your lordship.
Sir, but your client is not agreeing with you.
Yes, my lord.
You are agreeing with me.
I will agree.
The client, after taking the draft, after 2.5 months, claims pays for another 1 month.
That I agree with your lordship.
Sir, if that order is challenged, then the family judge will be in trouble. How the family judge has returned the draft and then has not, you see that order is still holds High Court order.
Yeah.
That 30,000 order still holds.
That.
So now the family court trusting the lawyer or the client has allowed the time.
Yes.
And that is after 1 month,
No,
1 year,
allowed by petition.
1 year.
Allowed by
And after allowing the petition after 1 year,
again.
so he has got, what should have done? The order should have been that you go encash and deposit it today.
Yes.
That could have been.
Yes.
But in good faith that could
She kept the draft also with her for some quite long time. She was sanction fere dele gaya.
I guess ଶୁଣନ୍ତୁ ଆପଣଙ୍କର
10 ମାସ ରଖିଲେ draft.
you are not, then you have not followed what I am saying, sir. Sir, after the court has passed to payment of 30,000,
ଆଜ୍ଞା.
ଯଦି ତାଙ୍କର ଟଙ୍କା ନବାର ଅସୁବିଧା ହେଲେ ସେଟା ଆପଣ ଫେରେଇ ଦେଲେ ନା. Thereafter also the court granted it 2.5 months time. You have received it.
ଆଜ୍ଞା ତାଙ୍କର ଯୋଉ ଅସୁବିଧା
ପରେ ଆପଣଙ୍କର ପ୍ରୋବ୍ଲେମ ହେଲା ଯେ ଆପଣ ସିନା ଆଟ୍ରିବ୍ୟୁଟ କରିବେ ସେ ଫେରେଇଲା ପର୍ଯ୍ୟନ୍ତ, ଫେରେଇଲା 3.5 ମାସ ଟାଇମ ନେଲେଣି।
ସିଏ ଆଜ୍ଞା 10 ମାସ ନେଲେ ମତେ ଆଉ ମାସ 3 ମାସ
ଆପଣ ତ ଟଙ୍କା ଦେଇ ଦେଇଛନ୍ତି ଅଲରେଡି। ଆପଣ ଟଙ୍କା ଦେଲେ ବୋଲି ଅର୍ଡର ହେଲା।
ଆଜ୍ଞା ମାସେ ସମୟ ମାସେ କାଇଁ
ମାସେ କେମିତି 15 ଦିନ କଣ ଦରକାର ଆଜ୍ଞା?
15 ଦିନ ସମୟ ଦେବି ମୁଁ
ଆପଣଙ୍କ ବ୍ୟାଙ୍କର କିଛି ଅଛି କି ଇଏ? ଆପଣ ବ୍ୟାଙ୍କ ଏମ୍ପ୍ଲୟ ନା କଣ ବ୍ୟାଙ୍କ ପଇସା ପାଉଛି ବୋଲି ବ୍ୟାଙ୍କ ଯୋଉ ଏଇଟା ଗୋଟେ ସଣ୍ଡ୍ରି ଆକାଉଣ୍ଟରେ ରହିବ ସେ ଟଙ୍କାଟା ବ୍ୟାଙ୍କର ବି ହବନି। ଯଦି I don't understand what is happening.
I will pay the cash, my lord. I will pay the cash. If your lordship issue notice here, I will pay. Or your lordship may direct me within a week or within 2 weeks, I will pay the cash to her, my lord. And they will restore. Only dispute is draft nebe na cash nebe. Mu dei debe again.
No, no.
I agree with your lordship that there is some latches on
your client doesn't agree. You agreeing what? Upon page 51 dekhantu. ଆପଣ ପେଜ 50 ରାଜର ଦେଖନ୍ତୁ।
ଆଜ୍ଞା।
In the middle, page 50 ରେ ଅଛି similarly adjournment is being paid in his petition dated 17/10/25.
Yes, the destitute wife has been running to this court since 9/17 and
so that is because of the Supreme Court that 25 ରେ ଆପଣ ଟାଇମ ମାଗିଲେ ସେ ସେଟାକୁ କରିଛନ୍ତି ଆପଣ 2.5 ମାସ ପରେ ଫେରେ ଟାଇମ ମାଗିଲେ
ସିଏ ମତେ ପରେ ସେଟାକୁ ନେଇକି 2.5 ମାସ ପରେ ଫେରେ କିଛି ଦିନ ପରେ ଫେରିଲା କି ସଂସଦ ଫେରେ ଦେଲା 13 ମାସ ପରେ 10 ମାସ ପରେ ତାର ଯେ ପ୍ରୋବ୍ଲେମ ହେଲା ଆଜ୍ଞା ସେ ମତେ 10 ମାସ
ଆପଣ ଆଜ୍ଞା 10 ମାସ ନୁ ଯେତେବେଳେ ବି ଆପଣଙ୍କ ପାଖରେ 2.5 ମାସ ଥିଲା ସେ ଧରନ୍ତୁ ଲେଖା
10 ମାସ ଥିଲା ଆଜ୍ଞା
10 ମାସ ପରେ ଫେରିଲା
ଆଜ୍ଞା
ଆପଣଙ୍କ ପାଖରେ ତ ଟଙ୍କାଟା ଅଛି କୋର୍ଟ ଆପଣଙ୍କୁ ଦେଲେ ନା you could not have accepted so you kept it for seeking adjournment after that after receiving the draft you could have directed that I will the court may direct the bank to return the money and give me. So we do not. It is a problem created by your client.
That's right. I agree. My lord. I will pay him. Your lordship may say 7 days or 10 days, whatever it may be. I will pay him, my lord. Otherwise, this order will not be given effect. This order will be given effect. Meritor ଶୁଣାଣି ହଉ କେସ୍ ମୁଁ ତାଙ୍କୁ 10,000 ଟଙ୍କା କେତେ 30,000 ଟଙ୍କା ଦେଇଦେବେ ଆଜ୍ଞା। Lordship may fix the debt within
in fact it appears that after because this order is passed 28/11/2025 so it is in fact the court got scared now because that order remaining intact for 2.5 years you have 2.5 months you retained the draft did not go to the bank. That was the concern with the court. It is unusual. You are right. That somehow the court has immediately passed the order, but after 2.5 months, it is the petitioner is the appearance actually. That's it. Mr. You kindly take your seat. I will take some time. Yes. Mr. Dharendra Naik, senior advocate, along with Ms. A. Misra for the petitioner. The petitioner is before this court challenging the order dated 28/11/2025 passed by the Lord Judge Family Court, Barampur. In CRP number 360 of 2017. Though various facts and issues are involved since the initiation of the matter in 2017, the issue before this court is that the petitioner, after receiving demand draft number 723068 देखिए लिखिए भूलवा नहीं जो पेज 46 रे अछि receiving demand draft number 723068 dated 23/10/2024 for an amount of rupees 30,000,000 which he had deposited as cost for setting aside कौन लिख ले सेंटेंस आउटर पढ़ो तो जो रिसीविंग लिख ले जी फॉर 30,000 ऑन लिखिबे 5/9/2025 05.09.2025 Mr. Naik, you have been called maybe. He can stay. I'll direct that you will be depositing the 30,000 by on which date?
As your lordship direct.
No. Because he's not listening. He is confused. I don't know what he's doing. Somebody having a draft of 30,000, he's not depositing in the court. That is very strange.
Draft to deposit ko tonka deposit. Draft to deposit ko.
Draft of bank ro Draft is not with him. The money is not with him also. The money is with the bank.
Yes.
He purchased a draft.
Again.
He holds it for and not depositing in court, saying on one petition or the other.
Court na.
Court deposit.
Court deposit करता था पर ता डेट पड़ेगा
तापर से तब धरी बुलची
ये लॉर्डशिप
5/9/25 रे रिसीव कला पर से काहेकी बुलुची सेटा गॉड नोस
लॉर्डशिप डायरेक्ट
केबे दे परिवेश that he should have told you. Actually, I mean, when the briefing council, you should have asked that this question to him. That after getting draft on 5/9, so why you are moving around not paying the money?
I have repeatedly
Now the court is actually
I have repeatedly asked you, my lord.
Court order was to pay 30,000.
Yes, ma'am.
The court in good faith handed it over to the person who is to deposit the cost. He has to deposit, go to the bank, get the money and deposit it.
I leave it to lordship to decide the date.
I don't know, because I
Again, that the judge.
even the second time, give second chance. I am not that expert.
Yes. Jati
How much time?
Mase.
Which day?
Mase.
Mase केम अपन draft अपन पाखर अछि
अच्छा 15 दिन
ठीक अछि 15 दिन कोन लेके receiving demand draft लिख लेनी की on 5/9 has not encashed the said draft purchased by him and deposited the money in the court as directed by order dated 5/9/2025 by order dated 24/10/2024 12/11/24 तो और एक्सपायरी डेट केबे इतला सेटा सेट केबे रिकॉल इतला जोटा से सेटा सेट कोच केले well by 12 order dated 12/11/2024
again
passed in the said CRP 243 of 2022 the learned court in session of the matter the learned judge family court the then learned judge family court Berhampur had recalled the earlier judgment dated 26/4/2019 recalled oblique set aside. The earlier judgment dated 26/4/2019 passed in CRP number 360 of 2017 and restored the petition to its file. Apparently, the petitioner wife had received the draft on 12/11/2024 and returned the said draft on 5/9/2025, which was received by the husband on 5/9/2025, but is yet to be encashed for depositing the amount of cash to be received by the wife. On being persuaded by the submissions of the learned senior advocate for the petitioner is granted a further opportunity to ତାଙ୍କର ଆକାଉଣ୍ଟ ରେ ଜାଣିଛନ୍ତି କି କଣ ସେ ବି କହିନଥିବେ ୱାଇଫ ଙ୍କର ଆକାଉଣ୍ଟ କିଛି ଅଛି କି ଏ ପ୍ରୋବ୍ଲେମ ହବନି ଟ୍ରାନ୍ସଫର କରିଦେଲେ
ନାଇଁ ତାର ଆକାଉଣ୍ଟ ନାହିଁ ବୋଲି ସେ ନଉନି ମୁଁ ଜାଣିନାହିଁ ତାର ଆକାଉଣ୍ଟ
କଣ ପ୍ରୋବ୍ଲେମ ହେଇଛି ଇଟ ଇଜ ଭେରି ଷ୍ଟ୍ରେଞ୍ଜ ଆଜ୍ଞା କଣ ଚାଲିଛି କଣ ଲେଖିଲେ ଫର୍ଦର ଟାଇମ ଦୋ ରିଲକ୍ଟାଣ୍ଟଲି
ସେ କିଛି ସେ ବି କିଛି କହିନାହାନ୍ତି ଏଇଥିପାଇଁ ମୁଁ କରିପାରୁନି ଡ୍ରାଫ୍ଟ
ଆଜ୍ଞା କୋର୍ଟ ଇଜ ଏ ଶୁଣନ୍ତୁ ଜଷ୍ଟ ଇମାଜିନ just let us take me. I pass a order of cost 30,000. Mr. I am not recording that, but obviously it is now part of.
Your lordship direct me to deposit cash within 15.
No. There is some problem, some other problem. That is now I realize why the court is facing this difficulty.
ये cash चाहूँगी आगे मुझे दे 15 दिन में.
Draft has to be produced. Because again, I am making the same mistake. Consciously, I cannot spoil your also. I will be spoiling your case. I mean the petitioner's case.
As your lordship
say draft shall be produced before this court
within a week.
Within
Barhampur ji bag see CORAM.
Whatever. Sir, there no problem. At least I should see. I mean. Because you know what order I was going to pass. I just stopped because
I find there is some suspicion, my lord.
No, not suspicion. It has become unexecutable. The court has done the mistake of returning draft. How the court can do this? The court should not have. But it trusted the lawyer. ଆପଣ ଟିକେ ଫେଭରାଇଟ ସେପଟୁ କରିଦେଉଥାନ୍ତି ମୁଁ ସବୁବେଳେ ମାର୍ଚ୍ଚ ଅର୍ଡର ଡାକି ଦଉଛି ମାର୍ଚ୍ଚଟା ଆହେଡ୍ ଉପରକୁ ଚଳିବ ଟିକେ ଉପରକୁ ବଢେଇଦେବେ in the week list, the matter shall be listed in the week commencing 23rd or 9th?
9th.
Who week rasibo? 23 week na the 9 week?
9th March.
List in the week commencing 9 March. So say the last roughly Thursday has to Quebec. The week commencing 9th March 2026. The draft shall be produced on the said date. Or you fix a date. Upon the date code. No, no, say anantu seta. So kon tapore God knows what they are doing with this. The self created problem. On 11/2/2026. 7 days.
Out to this 10 दिन.
Tal thik achi then it has to go on 23/2/2026. Okay. Yes.
My lord, NBW has been issued against.
And now it is very easy. Now though it is so clear as daylight. The court is really concerned. You file that memo. It will produce. I will affidavit done. I'll take it over after recess. Then I'll stay the NBW.
affidavit?
I have to. See the way. They move that produce kori. One line affidavit that I'll produce once. So that written lekhive. So I'll pass that order.
Yes.
I'll that much I'll take because of your persuasiveness. So that but this is a serious problem, Mr. Naik. Now I realize. No, the strategy is always that you do not present the court a very serious picture. Paint it very casual. किछि नहीं आएगा से ड्राफ्ट दे पाला नहीं टीमा से देरी करते ऑडियो भाषण
that is the reason.
There is something no. What about the order, sir?
Might be.
What about the order setting as an expert that judgment? Conditional order. So now that is a problem now. The court unwittingly has handed it over them. Anyway, let us come back.
Subject to filing on affidavit or not semester. I will not.
Yes, you bring that affidavit. ଏଠି ନେଇଥିଲେ କରିଦେଲେ
Recording in progress.
full stop ହେଇଛି the petitioner the learned counsel for the learned senior advocate for the learned senior counsel for the petitioner is instructed by the instructing counsel that the petitioner shall produce the demand draft bearing number 723068 of bearing number ete I am dictating as a case not of drawn on so and so achi upare dele amounting to rupees 30,000. Why did you write that I have returned it to the advocate?
Pardon?
Why you write which was returned to my advocate? Advocate has not prepared the draft.
ସେ ଆଣିଛନ୍ତି ସେ ତାନି ଦେବେ ଅଣ୍ଡରଟେକିଂ ଦଉଛନ୍ତି ଆପଣ ଆଫିଡେଭିଟ୍ ଦଉଛନ୍ତି
You should have avoided that sentence.
ସେ ଆଣିକି ଦେବେ ଆଉ
Whoever. You should not have. It is his draft. He has done the draft. कौन लिखले? हाँ. In response to the said submission, the matter was passed over, directing the petitioner to file affidavit after recess. ହେଲା ତାପରେ ଲେଖିବେ ସପାରା upon resumption of the proceedings of the court after recess na lunch break जोटा भी ठीक lunch break बोले कुछ तो lunch break affidavit of date is filed by the petitioner stating that he will produce the demand draft bearing number 723068 of 30,000 within 2 weeks. Dated ta पकेवे डेवेंडर हमको para. Apparently the draft has the demand draft drawn on SBI बोले so and so bank has not been encashed. जहाँ अच्छी से order है जहाँ अच्छी order है जहाँ अच्छी से so and so has not been encashed. The said draft upon production अच्छा ठीक है छाड़ दियो has not been encashed stop कर दियो से केबे डिपॉजिट करिवे 30,000 before that
within 2 weeks
डिपॉजिट सेठी कर देबे
ଟଙ୍କା
टंका केमती से रिसीव करिए because to save that order of now that order will grow actually that order conditional order of restoring the application
ଆଜ୍ଞା
that is impacted
ଟଙ୍କା ବି
କେବେ डिपॉजिट करिवे तनको पचार
ଟଙ୍କା 2 ସପ୍ତାହ ସେ ବି ସେଇ 2 ସପ୍ତାହ ଭିତରେ କରିଦେଲେ
that the petitioner further undertakes that he will deposit the amount of rupees 30,000 directed by order dated what गलत था 12/11/24 yes Miss Misra you should be
20
एक 28
और कौन लिख ले as directed by order dated 8/11/2024 pursuant to which he had deposited the draft on 12/11/2024
बाहर है
earlier order was 8/5 because
8/11 ना ଆମେ ଏଟା 26 ମାସରେ ଅଛୁ ତ
ଆଜ୍ଞା
तो डायरेक्शन केबे ହେଇଥିଲା अच्छा 8/5/24
19/4/2024
डायरेक्टेड बाय 8/5/24
ଆଜ୍ଞା ଆଜ୍ଞା
डिपोजिट कले
24/10
24/10/24
ଆଜ୍ଞା
डिपोजिट 24/10/24 सेठी आपण ड्राफ्ट नंबर और डेट पाइजिवे ड्राफ्ट जो डेट ता नहीं 23/10/24
अपडेट अछि नंबर अछि
होला सेंटेंस पढନ୍ତୁ Directed to be deposited now. By con. Directed to be deposited by order dated. On 12/11/24. 24/10/24, sorry. Yes, you are right. और भी confusion आ रहा है 24/10/24. ठीक है within आज ହେଲା के 4 तारीख आज 5 तारीख बाय 20 तारीख सुधा दी पारे
हाँ कोड़ी बहुत
by 20/2/2026 before the learned judge family court upon filing a petition to that effect, the learned judge family court shall allow the amount to be kept in the manner which can be received by the opposite party wife in the marriage. Stop. To that effect, suitable orders shall be passed by the learned judge family court Berhampur. List in the week commencing. Provided date को 23 तारीख 23 week रे दाव रखे पे
अजो नोट्स
25 the week list on 25 3/20/26 25 2/20/26
again
केन बोले 25 2/20/26
stage
in view of the affidavit IA होची 65 of 2026 the IA arises out of the present RPFM seeking stay of order dated 16.01.2026 passed in CRP 161 of 2024 arising out of CRP 360 of 2017. Learned Senior Counsel
191
reiterates
151 आ गया सेटा 191 CRP number 191 ना
भूलभाल हो गला सब टाइप भूलभाल हो जाए
एग्जीक्यूशन पिटिशन टा
अपना पेज
पेज केते
फ्लैग ए देखु नांती सेथिरे फ्लैग ए देखंतु मु देखु सेटा कॉस्ट टाइटल देखंतु सीधा टच कर दियंतु आपण बुक मार्क को जाके सीधा टच करंतु बोले येची
191 actually 161 भूल करछु 191
the first line लिखंतु it is submitted by the learned counsel for the applicant the learned instructing counsel Ms. Misra that inadvertent typographical error has crept into the petition. Stop. C6 to leave C6 leave to carry out necessary correction.
बाकी any correction कर दे उसको कर दो
Stop. Leave granted. The learned counsel is allowed to carry out the necessary correction in the cost title. सबुटी भूल दे ना से गोटे जगह भूल.
से गेट देयर
And the necessary correction to correct the CRP 161 of 2024 as CRP 191 of 2024.
या बॉडी ऑफ द पिटिशन में भूल हिच मु देखि दी कर देबो करेक्शन कर सेही पिटिशन ले एवरीवेयर 161 हिच 191 हिच 161 हबो ना
नहीं तळे 191 अछि पारा 6 रे 1 मु देखिला परे आपण पचारछु मु आगे पढी दे तापरे पचारे तो तोटी थिबो कर देबे ठीक अछि प्रेयर 191 अछि नहीं बर्तमान 191 ठीक ना 161 ठीक नल ऑर्डर भी भूल
191 ठीक तो
देखो तो से सेठी जदी इशू करे भूल तो से भी गला से पर आउरी कंफ्यूजन कोन लिखले
191
हां तो ये the correction shall carry the signature of the learned instructing counsel Ms. Misra to be countersigned by the court master से आइए काढी कि दियंतु हला तापरे ऑर्डर टा लिखिले ऑर्डर टा कोठी गला केते बाटा गला लास्ट लाइन पढो Affidavit of affidavit of debt is filed by the petitioner who is present in court. The affidavit is taken on record, scanned copy be updated. So please add kar dele. Last line कौन लिखते ले? In view of the his submissions. The senior counsel appearing to the petitioner reiterates his submission. He submits that unless the order dated 16/1/2026 passed by the Lord Judge Family Court issuing NBW.
Yes.
NBW is state the petitioner shall suffer irreparable loss and shall be highly prejudiced. It is submitted that the petitioner did not and does not intend to violate any condition as put by the learned Judge Family Court for restoring the matter by order dated. केबे restoration हला? 8/5/24
ଆଜ୍ଞା 12/11/2024 Christopher.
12/11/24
ଆଜ୍ଞା
12/11/24 Having heard the learned counsel for the learned senior advocate for the petitioner and after perusing the affidavit filed, affidavit dated by C, affidavit of date filed by the petitioner, the order dated 16 যেতে কইলে ইনেতে 191 সে ঠিক লিখিবে shall remain stayed till the notice till আমার কত তারিখ লিস্ট করছন্তি 25 shall remain stayed till নাই till 2 March 2025. Any I mean difficulty in listing it, latitude should be there.
maybe.
Yes. It would give it.
Copy of the order ma'am give it. Certified.
The urgent certified copy as per rules. Parties to act upon. The urgent certified copy as per rules. সেটা তো upload করে দেবে আপন। We'll try to upload it today. Yes. Yes, please. Next. Sir, your item is number. Najib operation.
Item 38.
Sir, pursuant to the order,
Are you a student of law? Because sir, this is serious hearing matter.
yes, sir.
If and you are sufficiently educated,
Yes, sir.
knowledgeable.
Yes, sir.
Today you are present in court on the last matter. I mean, the subject is very nuanced. There are so many things, so many aspects, multidimensional. I am not discouraging you in any manner. Please don't misunderstand me. But at times you end up arguing against yourself.
I understand.
So that and this is a serious thing. There can't be a kind of common room discussion.
Right.
I mean, we try to get out of our predilections.
Okay.
Suppose like I think that somebody is very bad, certain things to be done is very bad. That cannot be my approach.
Yes, sir.
It has to be
Process.
controlled by law,
Okay.
provisions of law, principles, jurisprudence. So that is how it becomes a difficult thing to argue a matter. And when you yourself you are arguing, you have your emotions. A human being without emotions is very uncommon. It need not be also. It's very natural. So what you are challenging?
Sir, I am challenging the order dated 9.
Say other side पड़े गले.
Sir, 8.
Achha, sorry, yes, you are there. Mr. Soru, yes, Mr. Om Soru. Mr. Roshan Patnaik in person.
Yes, sir.
Mr. Om Soru for the opposite party. Yes, please. Yeah, but कौन challenge करछोनी sir?
Sir, order dated 9/5/2025 which was passed by the Learned Family Court to Bhubaneswar.
The opening that since the petitioner is appearing in person by the previous order, it was directed, the matter was directed to be listed, to be taken up, marked at 2 p.m. Accordingly, the matter is heard. Yes. Yes, Mr. Patel.
So I have challenged the order dated 9/5/2025 passed by the Learned Family Judge Family Court 2 Bhubaneswar. Sir, in that order, I had there were 6 IAs that was pending in front of the Family Court 2, which was passed all in one go in one combined order by the Family Court judge. I have also attached my petition which I had filed in the Family Court, and along with their response that they had filed in the Family Court for this court to pass better judgment or more favorable judgment. The 6 petitions, out of the 6 petitions, 5 were rejected and 1 was accepted. And I will just.
The 9/5 order is Annexure 1, page 36.
Yes, sir. 36 to 63. So the entire order sheet ଅଛି 9/5/2025 ଟା ମୁଁ କହୁଛି କୋଉ ପେଜ ରେ ଅଛି. Sir, it is on the page number 57.
So this is in nature of a final order or in interim order?
Interim order. Of 6 IAs, out of which 5 were rejected, 1 was accepted.
What is the prayer in the main petition?
Main petition the prayer is child custody, either shared parenting or I should have the custody of the child.
That is still pending?
That is still pending.
Okay.
In the interim,
in the interim, what you want? What are the prayers in the interim applications? Can you say, please?
Yes. The first prayer was to my son is now 6 years old. He is studying in Eurokid Surjanagar, which is a daycare school. So he should be getting admission into a proper private school based on how we, as in myself and opposite party, were studying in Bhubaneswar when we were kids. So I have requested that I should be given that mother is not serious and is not able to get him admitted. I should be given the chance to get him admitted in a private school. This year, the Eurokid UKG re tapare tar padha se school le padha band hei jibo. There is no standard 1 in the Eurokid school. So I am requesting the learned court's indulgence to pass necessary orders that I should be given the right to search a proper school in Bhubaneswar based on wherever we can afford and proximity to the house, wherever child stays. Say hisabre goda order pass kara jao.
Both of you, though I mean, your relationship has run into a little bit of rough weather.
Yes, sir.
You are staying together or separately?
Separate.
In separate premises or in one premises, separate rooms?
No. Separate premises. Mother to the.
How far from each other?
So the wife's house is around 5 to 6 kilometers from my place. I am staying in Old Town, and she is staying. Her house is in Jagamara, but mother is not staying here. I have been visiting the child. Yesterday also I visited for my visitation, and I know for a fact.
No. Never veer up the track.
Yeah.
Always confined to your pleadings.
6 kilometers दूर रे रहूछु. मतलब 6 किलोमीटर आम घर टू तांको घर 6 किलोमीटर दूर.
वर्तमान जो स्कूल रे पढुचंती पुओ जोटा आपनकर पढुचंती जोटी पुओ जोटी पढुची I mean since he is a kid I can address him like that. से जोटी पढुची सेटा स्कूल टू तांको घर टू जोटी से रहूची पिलाटा
मोटा तांको घरे रहूची मोटा मोटी 5 माने मिड पॉइंट रे पडिवो टिके माने रेक्टेंगल रे पडिवो कि मिड पॉइंट रे पडिवो मो घर 5 किलोमीटर कम सेटा मु श्योर.
जो स्कूल वर्तमान पढुची सेटा तांको जोटी पिलाटा रहूची सेठू स्कूलटा 5 किलोमीटर दूर.
हां 5 किलोमीटर आम घर 5 किलोमीटर दूर.
आपण रहउचनी सूर्यनगर रे
ना मु छुआर स्कूलटा सूर्यनगर ओल्ड टाउन जागमरा वाइफ घर जागमरा. वाइफ एठी रहू नाहंती से तांकर जो माने पेरेंट जो माने सीनियर सिटीजन हे गेलेनी से माने उनका पाखे छाड़ दे कि छुआ को जाय चंती मजरा आसुंती. लास्ट आस्थिले मु जानिया भितर जनवरी रे किंतु तापरे लास्ट 20 days हला मु जतले विजिटेशन जाय छी देखिनी.
You had a visitation with the wife or the child?
Of the child. Yes.
So you intend to meet your wife or intend to meet your child? So now you are saying that when you go to meet the child, you do not find your wife. So how can that be so that cannot be, the court can never conclude.
I agree.
That since you did not meet your wife while visiting your child, she is upset. That cannot be.
Okay.
You must understand that actually.
I understand.
Yes. Yes, please.
Anyway, my first pleading was to get him admitted to a proper school. Second pleading was that छुआर school दीटा बेले सर जाउची. दीटा बेले सरला परे I can छुआ इन 6 वर्ष हेलानी. जेते बेले ऑर्डर पास हेतला जो ऑर्डर टाको बेसिस रे फैमिली कोर्ट देले से ऑर्डर टा पास 2022 हेतला छुआर बयस 3 years रो कम थला. एबे he is 6 years plus. So or at the time of the order he was 5 years 8 months. So I should be allowed to take him to park or wherever outside to meet him in a proper environment. And
Vegetation right rate.
again,
What was the terms and conditions? What was the modalities? Not the terms and conditions. Vegetation and contact rights order is there.
again,
Straight away go there. Go to that page where the earlier order is there.
2809-2000 coach sir page number coach.
Page. Straight away go to that page. 2809.
2022 रे से order pass हेतला. 39 page number 39. जितने
Office no 22.
हाँ
Kindly go through. Kindly place it.
page
So
number
that
43 रे
the can follow.
हाँ page
28/9/2022. This order, read it from the beginning. This order arises out of.
Okay. This order arises of the petition filed on 6/4/2022 with a prayer to allow petitioner husband to hand over the custody of the minor to him and to allow him to visit the child at least 3 times a week and to talk to the child through video conference every day. Detail.
It is spelled out.
Yes, sir.
Kindly continue reading so that we are.
It was
When
spelled
the
out.
order passed by a court, we must understand what the court was considering.
Yes, sir. It is spelled out from the petition that he has filed a civil proceedings number 632 of 2021 under section 7925 of Guardian Words Act for custody of his minor child. He has also filed divorce petition filed civil proceeding number 575 of 2021 against respondent wife, which is in sub judice. No,
Just for a second. Upon Guardians and Ones Act, option it is the Hindu Marriage Act compilation and nahi hai. Hala, itre nahi. Guardians and Ones Act. Please carry on. Yes.
On 26/03/2022, the respondent informed him that she is going to Bengaluru for her professional commitment, leaving the child with her parents. He protested her vehemently, saying that he is capable enough to take care of the child, keeping him at his house. Despite his request, the respondent left the minor child at her parents' place on 27/03/2022 and she left for Bengaluru. The minor is being deprived from the natural love of him and his mother, which is necessary for its best interest and welfare. He has met his child on few occasions since 16/3/2021. The child was very happy to see him and he and the child are emotionally attached with each other. He was taking all of its care while he and she were staying together. He has means and good environment at his home for proper growth and welfare of the child. The respondent is negligent and avoiding her duties towards the child by leaving him with her parents. It will be for the welfare of the child that if he will remain with his parents, upbringing of the child with the parents of the respondent at their house is not possible, as they are very busy for the wedding of their younger daughter. That too, the mother of the respondent is a working lady. Her sister is also a working lady. Her father takes liquor and the minor needs to be handed over to his custody. Tapare, should I continue?
Yes, of course.
Under such circumstances, it is prayed that the petitioner husband to hand over the custody of the minor to him and to allow him to visit the said child at least 3 times every week and to talk to him with the said child through video call every day. Respondent wife filed her objection stating that the petitioner is not maintainable. On 26/03/2022, she informed the petitioner that she is leaving for Bangalore for her personal commitment, leaving the minor child with her parents. The parents of the petitioner are suffering from multiple diseases and completely bedridden. There is no male or female in his family to look after his ailing parents. So his capacity for taking care of the minor at his house is uncalled for. He has filed for divorce case against her without any reasons. Question of deprivation of the minor from the affection of his parents is of its parents is incorrect. The minor has been staying with her since birth. She has been looking after the minor child personally. Question of handing of the custody of the minor to the petitioner does not arise as the child is only now at the age of 2.5 years. The petitioner has abandoned her with the minor child since 16/3/2000.
Mr. Patnaik, so one thing I forgot to ask you. This is being, available, it's an open platform, though everyone is not allowed, but it will be available in YouTube. You have any difficulty there or should we stop that?
I don't have any difficulty.
If it is available, no difficulty.
No.
Okay. Yes, please.
He is now at Bangalore and his younger brother is ignoring his ailing parents who are bedridden. Hence, the petition filed for handing over the custody of the child to the petitioner may be dismissed. Heard both sides, pursued the pleadings of the parties and pursued also the relevant provisions of the law.
Perused.
Huh?
That is a typical word, perused, not pursued. Perused.
Perused.
Perused is going through with consternation. Yes.
Oh, okay. Did
Did you ever appear in that TOEFL, test of English as foreign language? So these words are alimony, perused. All these words are introduced to test. You go for foreign studies. There is a TOEFL, GRE, TOEFL, Advanced GRE. So once somebody appearing in TOEFL told me. Then I was a student, just a student of law. I mean, I was in. Still, I continue to be a student, but in college, law school.
Okay. As per Section C of Hindu and minority
and
Guardian Acts 1957, the natural guardians of a Hindu minor is in respect of the minor's person as well as in respect of the minor's property, excluding his or her undivided interest in joint family property, are in the case of a boy or an unmarried girl, the father, and after him the mother, provided that the custody of a minor is not provided that the custody of a minor not completed age of 5 years shall ordinarily be with the mother. Under Section 6 of Hindu Marriage, Minority and Guardian Act, father is the legal guardian of his minor child. It is the duty of a legal and natural guardian to look after his minor child for his or her upbringing, making proper arrangement and providing maintenance to it. The court within whose jurisdiction the minor resides is competent to appoint a guardian of the minor. Generalization in favor of the mother shall not be made, that the mother as a parent to be always preferable to the father to retain custody of the child. There is a presumption in favor of the natural guardian as opposed to those who are not natural guardian. The claims of the natural guardian to the custody of the child should ordinarily be accepted. Such claim should not be rejected if he is not fit to be guardian or for conducive of the child's welfare. Welfare of the child is the paramount consideration. Main proceeding has been initiated under Section 7, 9, 25 and 25 of the Guardian.
Straight away go to please 43 seconds of para for the above discussion.
From the above discussion, the petitioner is allowed to meet his minor child thrice in every week for 2 hours, only at a suitable time at the parental house of the respondent wife, giving prior intimation to the respondent wife and her parents. He is further permitted to talk with it every day through video conferencing at a suitable time with prior intimation to the parents of the respondent wife. The respondent wife and all the family members of her parental family are to facilitate such visits and conversation through video conferencing with the child. The petitioner shall not create any unpleasant situation at the time of exercising his visitation right and contact with the child through video conferencing, which are not at all conducive to the interest of the child. Failing which, the petitioner shall be debarred to see and talk and spend time with the minor. In case the respondent wife or any of
so you want these conditions to be altered to how many every day you want visitation right?
Yes, so I am saying that I am staying in Bhubaneswar and child dita bele school chuti hoji mu taku school ru anibi am ghare lunch karegi tapare ta ghare chhade debi 6টা bele
etre se raji heba darkar, but the problem is that
chua raji sir chua
no other state raji heba darkar. You must understand.
I understand.
You would mark that why the court is it not unusual that when the father meeting the child, then it has to inform to the mother. The reason being, in these kind of interactions,
Haan ji.
these kind of interactions for meeting the child
Yes, sir.
amongst the three. The
Yes.
parents, the child,
And
you are
child.
attached to the child, the mother is attached to the child. And in our society, this grandparents' role is much more important
Yes, sir.
if you compare with the Western society.
Yes, sir.
If you, it's not a question of comparing or passing a value judgment. Whether ours is better or the Western culture society is better, that's a different thing. But here, the role of grandparents is very important in our society.
Yes,
It has been like that, and it continues to be so.
Yes, sir.
Where the grandparents are available. And when now you see, it's a case of claim and counterclaim,
Yes, sir.
or you can say claim, not claim, assertion and counter assertion.
Huh.
You have suggested that since she is not there and she goes to Bengaluru or stays at Bengaluru, right now she's staying at Bengaluru.
Sir,
She travels to Bengaluru.
yes.
That is your case. So why to say that is, he travels to Bengaluru, in her absence, the grandparents are taking care.
Yes, sir.
Now she says that you are having also difficulty. Your parents are bedridden. There is no one to look after them. And very rightly, and that shows your character also that you are taking care of your parents. I mean, there is nothing negative.
Yes, sir.
So in that scenario, she says that if the child is staying with her at her place, I mean her paternal home, and her parents are taking care of the child, and she contributes the way that she is. And I have read a little bit of psychology because of my close association with psychology through my in fact my mother, if I can say. So that is how, in fact, it has been seen that children of working parents makes them better children, better performer, you can say. I'm unable to say the exact words, but that way. So perhaps that is not a difficulty. Now the second aspect for you is that now he is 6 years old. You want more time in visitation right. Did you file any petition before the court for changing those? 3 hours or 3 times. Say, so have you filed that petition?
Yes, sir. When I'm saying that I will take the responsibility of
No. It's not a question of staying.
1 minute. No. The petition that I had filed was that you are suggesting was inbuilt in the petition that I had filed.
No. That is not a question of. So see, legal. That is how I say that when we started our journey today in understanding this problem or understanding this issue, I will say it's an issue. It's not a problem for you also. That it is very nuanced.
I agree.
It is not that something asked and tathastu kariki seda nahi hogani. So if you have moved the court, then now I have to consider. I have considered your initial starting point. Now I have to consider. I have to look at to understand what was your case before the trial court for changing these conditions.
Yes, sir.
Yes. What is that petition?
So page number.
I'm sorry, Mr. Patnaik.
Sir.
Mr. Patnaik, you had filed a petition for changing these conditions.
Yes. So
more time for visitation.
I have not said visitation. I am saying it is parenting. Why? Because
no, right now, when the custody is pending. So during your visitation, how much time you will spend during that time? It will be parenting time for you.
Exactly.
So you need not be worried about the exact narration. So if you have more time, so you want you see, whatever you do after his school hours is parenting. No difficulty. But first of all, it has to be a vegetation right for you. Vegetation and contact rights.
Yes.
So now, have you made that prayer before the court?
Yes.
So kindly show that petition and the prayer.
Sir, I will request you to go to Annexure 9, 105 page.
105.
105.
Yes.
Sir, page number 119.
No. Let us start with the first. What is the cost title? What is the provision? That is what I have been telling you, that this is not as simple as it looks.
Okay.
It is guided by some, enacted laws made by the legislature.
Yes, sir.
So your application, it does not show what is the provision you are relying on. Any application should at the first page must indicate what is the provision.
So these are interim applications.
So it is not there.
Sir, 100.
Annexure 9A. 9A is before this.
Yes. application on behalf of the petitioner seeking.
So there which provision you are solving, under which provision, which act? Because when I will be considering, I am not considering as what you call in abstract.
I agree.
ମାନେ ଆପଣ ଚାହୁଁଛନ୍ତି ଯିବା ପାଇଁ କୋର୍ଟ ଦବ କି ନାହିଁ ସେମିତି ସେଟା ହବନି. I have to refer to a particular say provision like you have referred to Guardians and Wards Act, Hindu Minority and Guardianship Act 1956. That is how though it is a normal human activity, it is regulated and covered by those acts.
Yes, sir.
So what is the provision you have sought for? So that is not there. Anyway, I mean, you prepared this petition on your own.
With the help of the advocate.
The advocate should have helped you in mentioning making it a proper petition.
So
application, cost title and everything, it is written as if it is a written statement. Anyway, so prayer, so kindly read that those paragraphs.
Yes, sir. So in this particular application on behalf of the petitioner seeking court's direction to get Master Pushan, which is the name of my son, admitted to a proper school affiliated to CBSE, ICSE in Bhubaneswar. And then I have given.
By the way, a digression. What does Pushan means?
Mo puona.
Then how is it? But artha kono?
Sir, Surjanko naru aschi. Surjanko gote one of the name is Jemti Arka.
Pushan.
Agya. Sera na haba. Pushana.
Pushana.
Agya.
ସେଟା ମାନେ ଷ୍ଟ୍ରେସ୍ ପ୍ରୋନାଉନ୍ସିଏସନ ନୁହଁ ହିନ୍ଦୀରେ ପୁଷଣ କରିଦେଇଛନ୍ତି ପୁଷଣ
ମାନେ ଇଂଲିଶରେ ନ ନାହିଁ ନା
ଠିକ ଅଛି ନାଇଁ ନ ଠିକ ଅଛି ବଟ୍ ଉଚ୍ଚାରଣଟା ଆପଣଙ୍କର ପୁଷଣ
ଆଜ୍ଞା
yes.
So here in this petition I had said that the Eurokid school ଯୋଉଠି ସେ ପାଠ ପଢୁଛି ଏବେ that is from the age that is suitable for the age of 2 to 5 years and when I had filed the child was already 5 years plus this petition. And I had prayed in front of the court that please help me get him admitted to a proper school. And in the last paragraph also,
Did he fail in examination? He was detained in school.
No, he was not.
So then why you are saying that he is still continuing? Because the day one cannot state away, because in our days, we used to get admission in school at standard 3.
Again.
ତୃତୀୟ ଶ୍ରେଣୀରେ ସିଧା ଯାଇକି କ୍ଲାସରେ ବସୁଥିଲୁ ସେତେବେଳେ ଆପଣଙ୍କର ଏଟା ଏତେ ରିଜିଡ୍ ନଥିଲା ଏଣ୍ଟ୍ରି ବର୍ତ୍ତମାନ ରେଷ୍ଟ୍ରିକ୍ଟ ହେଇଗଲା କ୍ଲାସ 1 ମାନେ ଆପଣଙ୍କର 6 ବର୍ଷ ପ୍ରି ସ୍କୁଲ ଷ୍ଟାର୍ଟସ୍ around 3 years. So these were not there in 70s, early 70s.
I totally agree with you.
No, it's not a question of you agreeing with me. So actually I'm trying to explain you that when you are saying that he's still in standard, because if he enters at the age of 4 a particular class, then he gets promotion as the age of 5 years to the next class. And a child studying little bit overage has a distinct advantage. You must understand that. I mean, that is a parenting hint to you. That suppose he should be now, you are saying that he should be, if he is 5 years, he will be still in, now it is nursery, KG, then
UKG. Standard 1.
Nursery, LKG, UKG. Then standard 1. He got admission in nursery.
See, preschool. Preschool, nursery.
So he's yet to go to standard 1 because he's still alive. He can't get admission in standard 1.
No, that
yes. So when you are saying that, because if you mark paragraph 3, the Master Pushan is staying, is still studying in preschool, which is itself. Which in itself is an indication that minor son is not having proper schooling. What does it mean?
Sir, it means that
studying in preschool cannot be the indicative of not having proper schooling.
Sir, I can elaborate on that. Sir, when I'm going to DAV Pokhari Port or any of the other DAV Pokhari Port Mothers Unit 1, which are basically midpoint to both of our houses, irrespective of what the custody decision takes place. In both the cases, जदि आपण LKG रे पसी न थांते ताले सर स्टैंडर्ड 1 रे डायरेक्टली एडमिशन न नांते कोजन सीट्स फुल मोर
नहीं एक्चुअली
मोर कहया कथा हो
that is everywhere in Cuttack and Bhubaneswar, maybe pan India phenomenon.
Sir, that is the reason why I was
yes Mr. Swarup.
Sir,
kindly take your seat. No, so basically I'm more kind of not on merits regarding maintainability and all that scope of RPFM. This is RPFM or this is writ petition? But writ petition is the nature of a revision or 226.
Yes, madam.
So if this suggestion of I mean it's common knowledge. Unless you get into a school having up to standard 12, the greatest hurdle is getting a seat after standard 10.
But in this.
So now there is no difficulty for you. I mean, there cannot be any difficulty why a mother will not require her child or son to study in a school. So wherever the child is to be admitted, that's a genuine concern for you also. So what instruction you have regarding that?
The child is having ADHD, means he has difficulty in speech.
ADHD full form?
I have to go through that.
Attention deficit.
Attention deficit hypersensitivity syndrome. I mean that is but it is not autism. It is dyslexia. Not dyslexia, not autism. No, I mean he will gradually. I think he will outgrow this.
Yes, ma'am.
Attention deficit hypersensitive disorder syndrome.
So for that, the mother's apprehension is that he cannot go and cope up with the child.
So did you hear how it? It is a coincidence. I always read the brief along with the lawyer or the person. I said a child who is little bit aged in the school, he has a distinct advantage. So that is what you are saying.
And the
ADHD you are saying.
ADHD.
HDHD. S remains silent. Okay. Yes. Then.
So he has a.
So who has diagnosed this? Kindly take your seat. Listen. We are not adjudicating, please.
Yes. He is going regular therapy, and the father is also visiting
therapy with whom? Therapy with whom? Where he is having his therapy?
He is having therapy at a center. I have to check that name, but his father is also going to visit the child at the therapy center also.
The therapist has advised that both the parents should be there with the child. There is no such advice.
And so there are few schools who cope up the child and give special attentions to the child having ADHD deficiencies. So there are few schools
like
where the child is undergoing preschool, and for higher studies from class 1, the kid the mother has had met the schools, and she has also is under the process to select kid or some other school where a special attention will be given to the child.
Right. So the concern of the father is genuine according to you. So you are saying that, but Mr. Patnaik, again, this I said without knowing anything about the child. Whether it's that my close contact with particularly clinical psychology and all that. So I think both of you are on the same page.
Yes, sir.
So if I think your concern is definitely, because that is my understanding. Many of lawyers you meet of your age who are having their kids, they need a transfer to a school where they can study up to class 12, are facing difficulty. Sitting here. Why I say lawyers? Because there might be someone sitting here who do not know. So usually the proper approach nowadays is that even after enforcement of Right to Education Act, still there is no adequate seat. There is no adequate seat. And almost for a student passing from a reputed school, and I'm not sure about, as you said, DAV, Chandrasekharpur or DAV Unit 8 or the other one at Pokhariput.
Okay.
But here, after passing out, there are only 2 schools. Third is in between. You have to go to
DPS.
What is that place? In between is Adhalia Pulnakara. It's a huge problem. So your concern is right. But you must also be I mean, you must take it. I mean, your child, I think that's not a problem. He will outgrow this gradually.
Yes, sir.
You have to be patient. And the best strategy would be that let him be little bit of, because of his attention deficit, whatever he's having, it is not, I don't know whether it is, I was just, because only to check in the Google, or that,
Okay.
as you call it, Google University now. So everything you ask Google. So I think this is not a disease like dyslexia or
No.
so could be, I don't know right now. So if any school like kid mothers, you said kid, particularly kid, if it can be that they will take care of the child, then it is good.
Sir, what I
Because
have
they are now. Suppose what you are saying could be correct. The judge or the judicial process does not have a straightforward answer to this. Like because you see, please. So that is how I was trying to. The purpose of asking you, your lawyer, whoever has advised you, application on behalf of, again, I am there only, that page 105. Application on behalf of the petitioner seeking court's direction to get master's portion admitted in a proper school. These kind of orders can be passed by which court under which provision? That is the first question I have to look into. Suppose now I get an answer. Right now you do not have because it has not been mentioned. For getting a student admission to a particular school, whether the court can take up that matter. Because it's not abandoned child. Abandoned child or disputed age, the child is lucky. More lucky to have both parents so concerned about the child. The parents may be having their issues in between. But as far as the child is concerned, what you said is absolutely correct, to the point, and what on behalf of the mother being said is absolutely also perfect. So these kind of, I mean, whether I have serious doubts as a High Court, exercising widest jurisdiction under Constitution as far as the state is concerned, but not the original jurisdiction of a family court. That I do not have. I cannot exercise those. I mean, suppose you say that section particular 9, 8, whatever you have mentioned, Guardians and Warrants Act or the Minority and Guardianship Act, I don't have that jurisdiction. But say you can say, so I must understand. So that is how I was trying to understand what the court could have done. Right now we don't have a straightforward answer. Mr. Om Swarup may assist us. Sir, you can examine whether the court as such can treat this matter. So if you are I mean, contacting school which can handle the child better, and obviously KIT International is located at which place?
Yes.
So it is not even. I mean, it is not a case where the mother wants her convenience. Because as you said,
child's convenience is so that 1.5 घंटा जो जीव स्कूल को 1.5 घंटा आसीबो जयदेव बिहार छक पर तो भिड़ बहुत
नहीं सुनंतु सेटा प्रॉब्लम होची दे सुनंतु सेटा that is not an issue. That is not an issue. That is the issue in our I used to walk to my school. Many of the students, they used barefooted. Then a school at 2 kilometers after entrance examination, all these things, topmost schools in Cuttack. The topmost school, those two schools are within 2 kilometers, another is 7 kilometers. So those days are gone. And traveling from Cuttack to Kid Square, one day there is in fact, it is a fact because I know somebody who was caught and I was impacted by that. 1.5 hours, 1 hour. It is a normal thing.
But every day,
but that cannot be a consideration because if you now we are taking these twin cities have taken a color of metro. There is a direction by the Supreme Court. There is a direction by the Supreme Court by the Honorable Justice Kuldeep Singh, who was directing DTC to carry all the students to school at 6 a.m. and he directed that the concerned secretary shall ensure it. So the persons at the level of joint secretary, that means here in principal secretary up to the state, they used to wake up in the morning. I knew one joint secretary. So he told that today I have to go for school duty. He will ensure that because in fact he was financial advisor in Ministry of Surface Transport. So those are the problems, but that is besides the I mean, a court cannot say that since it is 1.5 hour, it is bad, it is half an hour, and now the other part is that if the child is struggling at DAV Pokhariput or say DAV Unit 8 or DAV CS4, that is not, or maybe, and Mr. Swarup, wherever the father wants those schools, you talk there also if they have any facility for taking special care of this child, so that the child is actually, it's neglected is not the proper word. The child is put into a situation which becomes difficult for him when he gets further pressurized in his academics. That should not happen. So shall I pass that order? Both of you. That apart from going to regarding this particular application at 105, because vegetation and contact rate modification, today I think we may not be having time, because he must understand and don't take advantage of that. At times, person are arguing and these are matters where I mean, lawyers in family court, they are not allowed. That is a purpose. So if he has not made that prayer, he will make that prayer. That may be considered in its own merit. We may keep it to other day. So if the concern expressed is that the child is in still preschool, unless he goes to a school, it has become impossible actually. It has been impossible to get a lateral entry in a school where there is class 10 or it has become very difficult.
So it is possible at kit as mother as and it is not one
No.
it's
understood. अरे किट रे तो बर्तमान से कोन क्लास 10 रे पढिबो कोन आपण कहू
क्लास 1 रे पसिया पे किछि
सेटा कथा पडे मु आपण सेटा कहूची की आई गॉट सो व्हेन द चाइल्ड इज 5 इयर्स आपण क्लास 10 मु क्लास 10 कथा कहूची what he says is absolutely correct. A child who is not having a school where higher studies is available, it becomes impossible, and that problem is faced in ICSE schools now. Our kids or kids of many of you youngsters, I mean, younger to me, when they are studying in ICSE, because ICSE does not have 11, 12. There is a huge struggle.
Stuart, there is 11 12. I am
So what about of course I know Stuart. So what about
Convent.
ye convent, St. Joseph's convent? You know, it is one of the oldest. So
Sir,
Stuart, since when it is having 11, 12?
since when I don't know my
That you must understand. That was the reason, even for a substantial about 10 years back, it was mooted that ICSE should merge with CBSE. They are giving that baccalaureate Cambridge degree in 12, so that is becoming difficult for students to get admission. Did the child have any issue when he was born?
no. At that time,
Normal child,
so
normal delivery and normal activity.
Yes,
Yes, Mr. Patnaik.
sir, ठीक है sir.
Yes, please.
We will try to work out if we can find a.
You should.
Yeah, we'll try to.
You should.
Sir,
You must understand, sir. You must understand, sir. That day, the other day, I told you.
Yes, sir.
The other day, I told you. I think it was a Thursday.
Yes, sir. Purva Guruvar.
So I didn't know that I will meet someone. I just what I told that you must look at somebody, those who are not as lucky or blessed as you to have a child. Then you will realize what is the
Related to his progress. ମାନେ ଭଲ ପଡୁଛି ଖରାପ ପଡୁଛି ଯାହା ବି
ସେଥିରେ ଗୋଟେ କଣ ହଉଛି କି actually again they are scared of the thing. I mean, discretion is the better part of the valor. By not sharing, they are not having any difficulty, but they do not know if it is shared, what would happen. The world has become complicated actually. We do not live in a very simple world. Everyone is suspicious. Just I said you that don't be judgmental. So don't be suspicious also, but the school as an institution, they are not themselves sure. जे आपण कहले काले असुविधा हे जो कि किछि असुविधा न हे पारे
सर
the petitioner has been explained that arguing a matter regarding custody, visitation rights of parent, visitation and contact rights of either of the parent would require certain knowledge of law as well as knowledge of the procedure adopted by courts and also practices as per the CPC and other procedural laws. And he had chosen to argue his matter in person. The order impugned before this court in the writ petition was rendered by the Learned Judge Family Court in such 6 number of applications filed by the petitioner herein, seeking 6 different reliefs. The Learned Court has dealt with the Learned Judge Family Court in its order dated 9/5/2025 has dealt with the 6 separate applications. ଆପଣ ଯୋଉ ପେଜରେ ଆପ୍ଲିକେସନ ଟା ମତେ ଦେଖଉଥିଲେ ପେଜଟା ଆଉ ଥରେ କହିବେ 105 ପେଜଟା
Sorry,
ଯୋଉ ପିଟିସନ ଟା ଆପଣ ମତେ ଦେଖଉଥିଲେ ରିଗାର୍ଡିଂ ଏଜୁକେସନ ଆଣ୍ଡ ଅଲ ସେଟା ପେଜ
Yes, fine.
105.
ঠিক আছে
ତାପରେ
the application copy of the application at page 105 of the brief was taken up as the petitioner appearing in person had addressed the said issue. It is submitted by the learned counsel for the appearing for the opposite party that no, ता पूर्व लिखे. It is submitted for opposite party को पूर्व रेट लिखो. The learned counsel, the learned petitioner, the petitioner appearing in person. Please don't mind using the word learned. It is not. You are equally learned, but we are not using the word other than lawyers also. Mr. Swarup, you take your seat. कौन लिखे? Person was asked whether he can refer to any provision of law under which the petitions were filed and the reliefs in each of the cases were sought for. Stop. Obviously, not being a student of law or equipped with legal knowledge, the petitioner doesn't have any answer. But that would not impact the discussions. But that has not impacted the deliberation. The deliberation in the court today regarding study of the child. The petitioner and the opposite party have been blessed with a son, Ayushman Pushana, Pushan. As stated in the petition, तेरे number होनी Mr. Swarup, it becomes impossible. It becomes a C actually. आपण कौन number कौन case किछ तो बुझी होनी.
section ଥିଲେ interim ହେଇଥାନ୍ତା. section ଯେହେତୁ କିଛି mention ହେଇନି ସେତେ କୋଉ section ରେ interim ଟା
ନା ଆପଣ ଏଟା ମୁଁ ଶୁଣି କହିଲେନି. ମୁଁ ତ ସେ ଆପଣଙ୍କୁ ପଚାରୁଛି.
ନାଇଁ ସେଠି ଏଟା ଆଇଏ ରେ ଯଦି section
କିଛି ତ number ନାହିଁ କିଛି ନାହିଁ କଣ କେମିତି ହବ ତାହେଲେ?
ଯୋଉଥିରେ ସେକ୍ସନ ରହୁଛି
କଣ ଲେଖିଲେ? Just kindly sit down. I will note that. I will note the reason why it is not numbered. कौन लिखे? Sir, no. Aisman Kushar. Stated petition, which is at page 105 of the brief. He is studying in preschool.
Yes, sir. Eurokid Sujanagar.
Not necessary. Why to mention the name of the school? Okay, that is at Eurokids Surya Nagar, Bhubaneswar. Apparently, the 6 applications filed before the Honorable Judge Family Court have not been numbered. This is the exact copy, Mr. Patnaik. 105 is the exact copy.
Oh, sir.
So that is what I asked. In fact, I told you that there is a format of filing applications. Okay, you take your seat. Can I say? Have not been numbered. Or has application have not been numbered. The Lord Counsel, Mr. Surup, has an answer to that. He submits that since the petitions have not been filed under any particular provision and have not and there is no cost title to the petition, that could be the reason for numbering them separately and dealing with each of the application. Stop. To deal with, in considered opinion of this court, to deal with those applications, the provision of law should have been indicated so that it would have been easier, it would have been possible for the court to deal with same in the perspective of particular provision. Stop. However, considering the fact that the matter involves studies of a child, the Lord Counsel, the petitioner was heard at length regarding his perspective, PERSP, his perspective, and so also the Lord Counsel for the opposite party was heard. Evidently, the petitioner and the opposite party converge on the point that both of them want welfare of the child and the child to continue his studies. In a very good school with best of the amenities and facilities. It is submitted by the petitioner that due to dearth of seats in higher classes, as the number of available seats in school is very less compared to, is less, not very less, is less compared to the number of students. Usually, a child gets admission at the preschool stage in a school where education is available up to standard 12. It is further stated and submitted that at Euro Kids School, Suryanagar, Bhubaneswar, there is no avenue for further studies beyond preschool. Therefore, the child, therefore, admission of the child should be explored in school, into bracket small s. In the schools, plural, in school, into bracket small s, where education is available. Possibly up to class 10 or class 12. It is submitted, the mother, opposite party mother, should also take steps for getting the child admitted in a school where classes up to class 10 or 12 are available. Para, in response, the learned counsel for the opposite party submits that the mother completes, the opposite party completely agrees with the concern regarding study of the child. The learned counsel, upon instruction, and as has been stated in the pleadings before the learned family judge, refers to the issue regarding the child having attention dash deficit oblique hyperactivity disorder into bracket ADHD. Stop. It is submitted that it would be in the best interest of the child that he goes to a school where a child having ADHD gets best opportunity and is adequately taken care of. Then para. From the above interaction and hearing in the court, this court comes to a conclusion that both the parents are concerned regarding the education of the child. Both of them have lot of love and affection, as it would be for natural guardian towards their child. The concern of the father regarding the school admission process having already started and progressed substantially is common knowledge. Stop. Therefore, both the petitioner and the opposite party are requested to have convergence as far as studies of the child is concerned. Each of them will cooperate with the other in finding out a school where the needs of the child and his interest are adequately taken care of. It go, though it is obvious, though it would be obvious, but still the court also observes that the petitioner as well as the opposite party will rise above their individual differences and perceptions about each other for the welfare of the child. To give him best of life according to their ability. So when can you come back? That she has got admission or you have explored.
Sir,
How much time you will take?
sir, about 15 days ଆପଣ କହିପାରିବେ?
Yes.
15 days maximum. Karana, in this meantime, I will be going to 6 schools near their house. Basically, Khandagiri area jaha school achi. One school I have already gone, Khandagiri Mothers Public School, Khandagiri. And जो थे ସେମାନେ ରାଜି ହେବେ ଆଉ କିମ୍ବା ଯଦି ସେମାନେ ଯଦି କହିବେ କିଟ୍ କଥା.
But don't go individually.
Sir, if she is there only na.
ଆପଣ ନାଇଁ ଚେଷ୍ଟା କରନ୍ତୁ.
ହଁ ମୁଁ
the parties are directed. I have used the word requested. I can compel you also.
Yes, sir.
But anyway, that doesn't matter.
Sir, I can pick her up from her place.
So the parties are directed to go to schools together.
Yes, sir.
Mr. Swarup submits that there was some difficulty in getting the Aadhaar card of the child or the father. Aadhaar card of the child. He shall initiate the process of getting the Aadhaar card or any other identity proof of the child by talking to both the parties. You talk to him also. What is the requirement? He is not your adversary. A lawyer never becomes adversary because he is holding a brief.
I'm not saying that.
Then why you are not wearing a robe? He is wearing a robe because he's not identifying himself with the person.
Yes, sir.
So, कौन लिखेंगे? The parents shall initiate the process together for obtaining Aadhaar card or any other
other documents रे सर स्कूल रे मागु चंती किसी जो स्कूल रे पाठ पढुची एने तार किछि डॉक्यूमेंट्स भी आपण दियंतु बोली तो सेटा मो पे चैलेंज होची स्कूल कारण तांको स्कूल रे किछि दोना
किते बेस्ट होतरी आपनकर I think after today so it has been adequately instructed to Mr. Swarup because I have tried to draw a balance by not giving any observation regarding activity of any one of you.
Yes, sir. I'm just requesting that.
So I mean, everything should be done, facilitate, do it together, and go for the best interest. If you want any, I mean, hard person to go, you can go also, no difficulties. Jodi upon chaunchan je upon mane kathabarta hela bele au kiye rahibe. I believe both of you are competent and educated enough that you will do well.
Yes, sir.
So kahinki upon khojichan. And Mr. Swarup will be he will act as amicus curiae. In the sense, friend of the court will not be thinking about his client. He'll be thinking good of both of you. As far as the kid is concerned, you bury your all differences for the time being. And hope for the best. Yes.
Yes, sir. 2 weeks.
List in the week commencing 23rd of February 2026 for orders. It is hope. This court hopes and trusts that by the next date, the school for the child will be identified and the admission process shall be initiated, completed. Yes.
Sir, as per the order of the previous date, I want to file this memo in this court.
Sida apan you कहैतला सेटा को order हैतला
The पूर्व date रे 29
अछंदी
हां कभी सर कोची
The learned, the petitioner, the first opening line kar debe. The petitioner refers to the order dated 29/1/2026, paragraph 2, and submits that he is filing documents before this court, so supported by a memo, memo of date, co-dater,
5/2/2026.
supported by memo of date. Annexed to the memo of date. Copy of the memos have been served on the learned counsel for the petitioner along with the annexes. The memo along with the annexes shall be kept on record. Scanned copy be updated. But specific date कर दिया Mr. पढ़कर
So next Thursday.
25 तारीख को.
Thursday कर दो मुझे पे सुविधा सर.
26 तारीख को.
26 तारीख.
ठीक है जी. List on 26/2/2026. Mark that 2 p.m. as the petitioner is appearing in person. Yes.
May I pray my lord? So item number 25.
25, sir. Yes.
25. I am for the opposite party.
Tomorrow this bench may not function.
Because why I am saying
So all these matters, and I have some assignment now. I can continue, but since I have assignment now, so I have to go, and all these matters will be distributed. And wherever you suggest a date, he will give, but the pattern is like that. Old matters will be given a priority, and then fresh admission orders after notice.
mine because I am not
Please. Because tomorrow is the date for appearance. Please wait. All at once.
item 25 be listed
There is a transfer petition, my lord.
tomorrow my lord.
Upon appear करिए सेटे time नियंतु. Mr. Mishra, what is happening? As I find that in case of a petition filed, they are not appearing there.
Well, it is distance on the lot of distance.
You engage a lawyer. You engage
From Bhubaneswar to
not can be Bhubaneswar in matrimonial matters. The Supreme Court has found out that it is rightly on the southernmost part of the country, northernmost part of the country. So ICT facility. So you engage a lawyer. I cannot. I don't understand this. That they are not engaging any lawyer.
Monday taken up.
My lord,
ଆପଣ 8ଟା Monday କୁ ଆପଣ ସବୁ fresh admission କେତେଟା ରହିଲେ? Today it was really a slow day. ଆପଣ 13ଟା ଖାଲି ଲେଖନ୍ତୁ. Mention କେତେଟା ହେଇଛି? ଗୋଟିଏ, ଠିକ ଅଛି. Just give me a minute. What is there? Left out matter ଗୋଟେ ଅଛି ମୁଁ କରିଦିଏ. Item 13 ହେଲା.
my lord, I have got a very small matter to be decided by the
Mr. Lingaraj Sorangi for the petitioner. The petition has been filed by the husband in the marriage. Challenging the order dated 20/12/2022, 20/12/2022, passed by the Lord Judge Family Court to Bhubaneswar in CRP number 49 of 2012. The said order reads thus. Page 35 order ta quote kar debe. Hala? So, today at the beginning of the proceeding, the Lord Counsel for the petitioner mentioned the matter and filed memo of date, which states thus. Date that quote kar debe. The petition stands disposed of. Copy of this order shall be forwarded to the Lord Judge Family Court 2 Khordha, Family Court -Roman 2, capital Roman 2, Bhubaneswar, to be kept in the records of CRP number 49 of 2012. Yes.
Item 39, my lord.
Page wise pade. Slow down actually. Next page 1 रे कौन मेंशन अछि किछि?
Item
8 कौन आपण 88 सुनंतु जतक फ्रेश मैटर रहिला ऑर्डर सब जगह लिस्ट कर दियौ. Fresh matter order ସବୁ ଜାଗା Monday ହେଇଗଲା.
ଗୋଟେ one submission lodge.
I have got a very small matter to be decided by the Honorable Court. My lord, I am.
Mr. Patnaik,
My lord. Item 7 here also.
Mr. Patra is here.
I am here, my lord.
Patra Monday.
I have got a very small matter to be decided by my lord. I have
Sir,
got.
Sir, please appreciate court time is over. I have some assignment. So I have to stop somewhere. Given a choice, I could have sat. I mean, since so many hearing matters were there today, so we have slowed down. So all matters will be Monday not convenient to anyone, please tell. Up to item 22, will come a item 7 jayengale. 7.
Item 7 जाएंगे.
7. So item 7 to 22, anyone having any reservation about Monday?
But 21 ଟା ଖାଲି fresh notice ଯିବ. Notice ଟା ଭୁଲ address ରେ ପଡିଥିଲା ଖାଲି notice ଟା ଯିବ. I will take
Mr. Tripathi,
Monday.
ସେଟା ଆସୁ.
Monday ଆସୁ.
Let us not pass order.
Item 22 please.
9th Monday, Tuesday.
Tuesday ନହେଲେ ଆଉ ଦିନ ଆସିବ ତୁ ନା ଫର୍ଦର ଟାଇମ୍ ଚାହୁଁଛନ୍ତି?
ନା ଏନି ଦେଖ ଖାଲି Monday ଟା ନୁ
ନାଇଁ ମୁଁ ସେଟା କହୁନି, ଆପଣ Tuesday ଚାହୁଁଛନ୍ତି ନା ଫର୍ଦର ଟାଇମ୍ ଚାହୁଁଛନ୍ତି?
ନା କରିବାକୁ ଚାହୁଁଛି
ତାହେଲେ 9ଟାକୁ ଶୁଣନ୍ତୁ ହେଲା, 9ଟାକୁ କରିଦେବେ Tuesday.
ଏନି ଡେ
11ଟା ଆପଣ ଯଦି ଚାହୁଁ ମେମୋ ଦିଅନ୍ତୁ, ତାହେଲେ ଆପଣ ସେଟା ମେମୋଟା ଦେଇଥାନ୍ତେ ନା ସକାଳୁ. ମୁଁ ତ ନଉଛି ମେମୋ ସେମିତିଆ ମେମୋ.
No, my lord.
ଇନଫ୍ରାକ୍ଚୁଅର୍ସ ତ 11ଟା.
If adjourned to Monday, it may get infructuous.
ଏମିତି ତ ହବା କଥା ନୁହଁ. କଣ ଇନଫ୍ରାକ୍ଚୁଅର୍ସ ହେଇଯିବ କି?
My lord, I am seeking the illegal action pertaining for encashment of the bank guarantee under annexure 2, my lord.
କେବେ ଅର୍ଡର ହେଇଥିଲା?
There is no notice issued.
କେମିତି ମୁଁ ଇଣ୍ଟରଫିୟର ବି କେମିତି କରିବି? ଆରେ ଆପଣ ବୁଝିପାରୁଛନ୍ତି ତ? ହାଇକୋର୍ଟ must interfere in order.
Yes.
Like you have heard the matter, he was arguing in person.
In similar
No petition. No reference to this provision.
in absence of imperial order, while not inclining to entertain the writ petition, it was directed for enforcement of the law only. That was a eviction case. Subject matter was different. What your lordship is saying that in absence of imperial order.
The eviction the more jurisdiction no.
No, my lord. The subject matter was different in the order I am referring. But the issue is in absence of imperial.
এই যে বিমলিনী সাহু ଆପଣ ଦଉଛନ୍ତି, how Bimolini is connected to Joy Matarini?
My lord, para 4. In that matter also no notice was issued. The honorable coordinate bench decided that the writ is not entertainable in absence of notice. But it was made clear.
So ସେଇଟା ଶୁଣନ୍ତୁ, ଆପଣ କେବେ ଫାଇଲ କଲେ? when did you file the writ? 26 ରେ ଆପଣ ଫାଇଲ କଲେ. କେବେ ଆପଣ cause of action କେବେ? So those things I should not. Once I am stopping for some reason, so you have to entertain, because these things will happen in a personal law matter. Somebody will appear in person, he will not understand, there will be prolonged hearing. Otherwise, it is in fact every day I am reaching hearing matter. So Monday as you, I will not.
Item 22 not in Monday, please.
11 interim order कौन चाहूँ?
Status quo till next date, because even if the
Item 11 equal to paucity of time intervenes, the matter could not reach. The learned, it is mentioned by the learned counsel for the petitioner that the petitioner, but the status quo will be till Monday, Mister.
yes,
Till Monday.
till Monday.
Mr.
Item
11 is appearing.
Web copy may be item 11 with letter.
Lordship, he assigned me the matter.
Mr. D.N. Lenka. Mr. D.N. Lenka for the OP number 1-3.
He is here.
Yes. So Lenka, he is saying the matter is not reached due to paucity of time. So he says status quo to be maintained. I say only up to Monday.
No status quo.
Till Monday, because I can't hear this.
He has stated in his petition that oral statement that certain
Sir, yes, he is candid.
So there is no,
Mr. Lenka, I asked him, he's candid to say that no, I have not touched.
and the government has allowed up to 30th April
No, it is not that he's saying there is some threat. He said, no, I do not know. I have not annexed. I mean, everyone is present.
The government has allowed up to 30th April.
अरे
No question of
sir, ଆପଣ ଯୋଉଟା କରିବାକୁ ଆଜି ଆପଣ କାଲି କଣ କରିବେ କି କିଛି ଆପଣ ଯୋଉଟା କାଲି କରିବେ ସେଟା ମଙ୍ଗଳବାର ଦିନ କରନ୍ତୁ ଦ୍ୟାଟ୍ ଇଜ ଦ ଓନ୍ଲି ଅର୍ଡର
Yes, sir.
ସେ ତ କିଛି ହାଇଟ୍ କରୁନାହାନ୍ତି ତାଙ୍କୁ ପଚରା ହେଲା ଯେ ଆପଣ କୋଉ କଣ ଅର୍ଡର ଚାହୁଁଛନ୍ତି he says that I have not.
My lord, sir, I
ठीक है 1 second सरू ଗୋଟେ मिनट
We are not going to, your lordship may say, we are not going to take any course of action because the state government has allowed up to 30th April 2026 to return the package. So question of
pending ଏଠି କାଇଁ ରଖୁଛନ୍ତି?
Yes, ma'am. I am seeking that any action will be subject to taking into consideration that extension under Annexure 3.
ଆରେ ସେଟା ମୁଁ କେମିତି କହିବି ସେ ତ ନିଜେ କହୁଛନ୍ତି ଆପଣ ସେଟା କାହିଁକି ଆପଣ that should be given full effect to.
Yes, my lord. That.
So then Annexure 3 you are saying that we have given Annexure 3. So it should be disposed of. You find that memo.
Yes, my lord.
Yes.
Sir, so what Mr. Lenka is saying that till what is that date?
30th April 2026.
30th April 2026, at least you have time.
Yes.
Yes.
So why you are bringing yourself in and have no time?
The OP number 4, my lord, not withstanding to that extension, has conducted a physical.
ଦେଖନ୍ତୁ ଡେଟ୍ ଦେଖନ୍ତୁ କେବେ ହେଇଛି
I am seeking that.
ଆରେ ଆପଣ ଏକ୍ସଟେନସନ ଡେଟ୍ ଟା ଦେଖନ୍ତୁ ଭିଜିଟ୍ ଡେଟ୍ ଟା ମତେ କୁହନ୍ତୁ ୱିକ୍ ଅନ୍ ୟୋର
Page 23 your
ଯୋଉ Annexure 3 କେବେ ଡେଟ୍ ହେଲା ଆଉ OP ନମ୍ବର କେବେ ଗଲେ
31/12/2025 रे Annexure 3 इश्यू ହେଲା जोटा एक्सटेंड ହେଲା 30 एप्रिल पर्यंत
करेक्ट
OP4 30 जनवरी 2024
ଜାଣିଛନ୍ତି କି ସେଟା OP4 ସେଟା ଜାଣିଛନ୍ତି କି ସେ ଯୋଉ Annexure ଟା ଆପଣ ତାଙ୍କୁ ଦେଇଥିଲେ କି
ନା ଇଟ वाज ବହୁତ
ଏଟା ଅଲଗା ଲୋକ
ଇଟ वाज
ସେଟା ଆପଣଙ୍କର ଯୋଉଟା Annexure 3 ଟା ଯେ ଇଶ୍ୟୁ କଲେ ସେ କିଏ
गवर्नमेंट ऑफ इंडिया सेम डे रे गवर्नमेंट ऑफ
ସେଟା गवर्नमेंट ऑफ इंडिया ସେ ପାର୍ଟି CSO
नो
तो ଆପଣ କେବେ ଆପ୍ରୋଚ କଲେ CSO କୁ
पेज 21 टा देखो पेज 21 रे समस्त सब सिविल सप्लाई ऑफिस को स्टेट रो फॉरवर्ड है छे नोटिफिकेशन
अरे आपण को जेतो से विजिट कले आपण जानिथिले आपण तो देखिले कि दैट्स अ वेरी सिंपल क्वेश्चन आस्क्ड टू यू एंड व्हाट वाज हिज रिस्पांस सो दैट आई कैन असेस व्हाट ऑर्डर आई विल पास
आई हैव नो इंस्ट्रक्शन बट
then what sort of you are making out
एंड भाई Annexure
आपण तो सेटिक एक्सरसाइज करिवे आपण क्लाइंट को पचारिवे मु जेतो एटा कोर्ट रे कहिबी आगे शुणु how the court will presume that Annexure 3 will not be noticed by somebody. Court cannot. A government of India order issued to all. How the court will say that they are not looking at it. So you must have some assertion on that. You should have ascertained that yes, he was shown this order and he did not listen to me.
that was
कोठी आपण लेक्चर
Annexure 4 मतलब पेज 20
Annexure 4 रे केमति लिखिबो मो पिटिशन रे लिखिबे ना Annexure 4 रे लिखिबे
Annexure 4 is the representation he has submitted that I may be allowed as per the government of India. That is the representation that your lordship may dispose of that representation. We have no on this.
34 पर्यंत मु देबो 34 आगरो जो कोर्स एक्शन एंड कैशिंग बैंक
ठीक अछि you have to wait for your order to be passed. Others are standing, you wait. Mr. Lenka, kindly spend some more time. Yes.
item
এটা দিয়ে দিন
item 22 no, I cannot present 22
ଆପଣ ସବୁ ଜାଗା ମଣ୍ଡେ ଆଣି ପାରିବେ ତ ଗୋଟେ ନା ଟ୍ୟୁଜଡେ ଦି ଦିନ କରିବେ ଟ୍ୟୁଜଡେ ଯାଏ କିଛି ଯଦି ଅସୁବିଧା ଅଛି ଲାଇକ୍ ମିଷ୍ଟର ସିଂ ସେ 22 ଚାହୁଁଛନ୍ତି
12 it can be
12 ଫେବୃଆରୀ ନାଇଁ 12 ଫେବୃଆରୀ କଣ ଡେଟ୍ କହୁଛନ୍ତି ଆମର ୱିକ୍ କମେନ୍ସିଂ 9 ଫେବୃଆରୀ ନା 23 ଫେବୃଆରୀ I'm not giving a specific date. He's listing week wise.
Which comes as 16.
16 to difficulty is. No, it's just जल्दी पे करो
no 9
9 कर दो ठीक है
My lords, item 29.
नेक्स्ट वीक तो नहीं था कोन कोई दिन ओटा नया से क्वेश्चन से तर सोमवार को छाड़ दियो तो बेसी लिस्ट लोड हो जिवो आपण 11 रो 13 भीतर
12 तारीख
कर दो ठीक है
My lords, item 29.
ना ना अरे पेज 3 रे कोड 29 अछि देन पेज 3 and 4
3 my lord item 25
हां 25
only 5 to 6 minute matter will be disposed of if this matter will be listed on 11th 10th Any day.
10th 11th this is after notice matter. After notice matter ଆପଣ we commencing ରଖନ୍ତୁ 23 onwards ରଖନ୍ତୁ 23 କି ମାର୍ଚ୍ଚ ରେ ରଖନ୍ତୁ.
Because my lord,
Already there are memos. The problem is that when you adjourn matter specifically, those matter cannot be deferred.
Since 22 the matter. more ତ ଆଜ୍ଞା ଉଠିଲାନି ବହୁତ କଷ୍ଟ
ଆପଣଙ୍କର everyday some hearing matter will be there. We must hear some matter. ଖାଲି press matter list କଲେ ହବନି.
ମୋ matter ଟା ଆଜ୍ଞା
ତାହେଲେ we commencing 23 ଆପଣଙ୍କର
ମୋ opposite party ମୁଁ concede କରିଯିବି ଯେ ହଁ allow କରାଯାଉ ବୋଲି ଏତିକି ହଉଛି କଥା ଯେ expertise
ଏଟା କେତେ ଏଟା 25
item 25
ଆପଣ ତ ପାର୍ଟି ଆପଣ ତ ହଁ ଅଛନ୍ତି ରବୀନ୍ଦ୍ର କୁମାର ପୃଷ୍ଟି
expertise order ଟା ସେ
25 ତାହେଲେ ଆପଣ ଅର୍ଡର୍ସ ପାଇଁ ନେଇ ଆସନ୍ତୁ କୋଉଦିନ ଆଣିବେ 11 ତାରିଖ ଠିକ ଅଛି 11 पर ऑर्डर्स तापर 26 ରୁ 29 ଜଣ मेंशन
My sir, 59 the B1
कोन B1
दीटा मैटर अछि TRP CRL
अच्छा माने फर्स्ट मैटर अच्छा हां B1
मैटर टा I am withdrawing
पुलिस B2 ला कहले पुलिस को ड्यूटी था B1 B2 अपन से होला कहले वाचन वा ड्यूटी न था कि से बुलंती ताकर कौन B1 कौन करिवे
TRP CRL 25 रे मु एली मदर इन लॉ एंड फादर इन लॉ एंड हस्बैंड माय लॉर्ड्स सेटा मु विथड्रॉ कर दउची
कर दियो
with the liberty that the my lords the trial
आर सेट वाले
ऑप्शन वाइफ पई अछि
सेकंड विथड्रॉ कर दियो तो स्कोरिंग
सेकंड टा मु कहूची अलाउ कर दियंतु से वाइफ ट्रांसफर सिक करजंदी जे बालेश्वर फैमिली कोर्ट रु राउरकेला को जाऊ
ठीक अछि
सेटा अलाउ कर
ठीक अछि दैट ऑर्डर आई विल पास 29 विथड्रॉ को डाकिबे सेक्रेटरी को डाकी
My lord,
now सब आइटम टा अलाउड जॉइंट मेमो काई मेमो दियंतु कागज काई आज्ञा
देली पर
आपण चैम्बर जो जंती कागज नछो हम धोला कागज रे दियंतु काई गोटे नंबर दीटा केस हवन
ना गोटे आ गोटे दे दूची ए टीआरपी सीट रे दे दू
हां दियंतु आज्ञा से पर अछंती आपण अदर साइड देखि देबे दैट द parties agree for the matter to be prosecuted before summons.
तांका प्रेयर टा अलाउ होई
आउडे मेमो कागज दियो तो मेमो दे
मो पारे अछि लिखि दू
से लिखि दे दो करेक्ट हां गॉट इट
माय लॉर्ड्स मारो प्रेयर होची जे the trial court may be directed to dispose of within a short
सेटा सुप्रीम कोर्ट बहुत लागू चंते
ना डीभी रे की डीभी टा रे की सेटा डीमा सरीवा का
अलाहाबाद एसोसिएशन और जस्टिस ओक्स जजमेंट देखंतु द सुप्रीम कोर्ट हैज टेकन स्टर्न व्यू ऑन दैट आपण जेतले कहबे जे दैट इज ओनली डीवी केस पेंडिंग बिफोर दैट कोर्ट पूर्ण केस नहीं ताले किछि करि हबो सेटा केही को नास्ती
माय लॉर्ड्स आउट होची प्रेयर होची जे विदाउट इंसिस्टिंग द पर्सनल अपीयरेंस ऑफ द पिटिशनर्स
सेटा व्हाटएवर सेटा आपनकर जोटी आईसीटी चाहउचंती तो
आया
से ऑर्डर फॉर ही
आया
आपण जदी एप्लीकेशन देबे
आया जदी इवेंट ऑफ नेसेसिटी
ड्राफ्ट धर के बुलचंती 4 मास हे गलानी अब कोर्ट नॉन अवेलेबल वारंट इशू करले तापर कहे जे हमर पर्सनल अपीयरेंस काहे गेला सेमती कोन हुए ड्राफ्ट नहीं पळेले कोर्ट रु ताको गला तापर कोर्ट आपण पुछरे पड़िबो कोर्ट चाइसडा गोटे चलला बहुत समय आज गोटे मैटर से ड्राफ्ट को कोर्ट गुड फेथ ताको दे देले कहले तुम आनी दे देबो से गले तापर आ आसिलेनी सेमिति कोन आईसीटी आपण तापर
इन द इवेंट ऑफ नेसेसिटी
ना आपण एप्लीकेशन फाइल करिवे कोर्ट सेटा कंसीडर करिवे आपण जो वर्चुअल कोर्ट वर्चुअल डिपोजिशन एवरीथिंग हमर फैसिलिटी अछि but that application you have to file आपण कथा करे मु जिबिनी कोर्ट को सेंती कोन हे परियो हबन it is impossible to conduct the case yes
मिनट आइटम 39
सुन पेज 532 34 के कोन कहउचंती ठीक है बट आपनकर किछ थिला
35.
ओके नेक्स्ट 35 प्लीज
Taken up week commencing 9 if possible.
9 तो नेक्स्ट वीक ता माने कहउछन ना
I
23 ही पारू 23 ही जो
23 February.
23 वीक कर दियो ठीक अछि 23 वीक कर दो हला 23 पर बेसी गला नहीं मैटर एनी जा आइतिबो देखि देबे ठीक अछि 36 टू 40 आपनकर 39
मतलब 39 एटा इंफ्रास्ट्रक्चर से जो खाली आ किछ ना ऑलरेडी
ड्यूरिंग मैटर कोन इंफ्रास्ट्रक्चर से जो आगे
मतलब तरफ ओरिजिनल जो ऑर्डर ऑलरेडी जजमेंट पास्ड बाय द कोर्ट बिलो जे खेमने बाहागर हेई नाही बोली नॉन एंड डिक्लेयर हेई सर जेडो इंट्री मेंटेनेंस पे से खाली ऑर्डर हेतला इन बिटवीन ऑन
ईवी एक्ट ना को एक्ट रे
नै फैमिली कोर्ट एक्ट
अरे मेंटेनेंस सर कोतरे क्लेम करले
124 मिनट हिंदू मैरिज एक्ट
सेक्शन 24 द मेंटेनेंस पेंडेंट लाइट ताले 24 टा तो मर्ज हो गला मु कोन करबी
नहीं ऑलरेडी सेटा केस दैट आई इज पेंडिंग बिफोर दिस बिफोर द ऑनरेबल लोअर कोर्ट
काइली मु कोन कहूची मो कथा बुझले कि गोटे सीपी फाइल हला डिवोर्स पे सेक्शन 24 फाइल हला मेंटेनेंस पेंडेंट लाइट आपण जदी कहउचंती मु ठीक बुझीची सीपी हैज बीन डिस्पोज्ड ऑफ सो 24 गोज
मतलब जैसे इंसिस्ट
25 क्यों कोई परिबेनी और if there is a 25 order with disposal to section 13 application if there is a 25 order 24 merges with 25 आपनकर कोन हिची से ठीक रे मते कोन
एटा 24 रे ऑर्डर ऑलरेडी कंटिन्यू करू बट सीपी ऑलरेडी सॉरी जाई तळ कोर्ट रे
लास्ट ऑर्डर ता देखंतु आपनकर जोथरे सीपी टा डिस्पोज ऑफ हेची आपनकर 24 ऑर्डर ता केमती कहउचनी मर्ज कला बोली माने चालची बोली item 39
item 39
आपण एटा जो दिन एटा देखन ऑर्डर ता हेची 17/12/25 आपण एप्लीकेशन फाइल कले के डेट देखंतु सायंतन पंडा सो सायंतन पंडा के फाइल कले आपण 13/11/25 रे फाइल कले सर बुझिले ना
आगुरु फाइल कर ए जजमेंट आगुरु फाइल करथले ए ऑर्डर आईआर ऑर्डर थिला तेनु खाली ऑनरेबल हाई कोर्ट को ऑन परडा पेंडिंग अछि तो केस को बंद वांट टू डिस्पोज दिस केस
आपण 24 रे आपण एथरे होचंती 24 सेक्शन 13 के फाइल करथिले
सेक्शन 13 नॉट तो हमें बाहागर को नॉन एंड डिक्लेयर करिया पे सेक्शन 11 एंड 12 रे फाइल करथिले
के फाइल करथिले 11 12
द प्रेजेंट
पिटिशनर हस्बैंड ना वाइफ हस्बैंड तांका पिटिशन अलाउ हे गला वर्तमान से चैलेंज कले सेक्शन 24 ऑर्डर टाकू
ता पूर्व करथिले जते बेले डिस्पोज हेई नथिला सेते बेले
से ता पूर्व से डिस्प्ले डेट पचले आपण मते कहू नांती म कोन करिवि तापरे वर्तमान 24 ऑर्डर टा कंटिन्यू करछिले आपण केमती कहउछन एटा तो जजमेंट हे सरलेन
नहीं
तोरकी हुएनी कोनोसी ट्रायल को एभलिया भूल करिवेनी इंट्री ऑर्डर केमती कंटिन्यू करिवो कहउछन
नहीं कंटिन्यू
आपण से ग्राउंड रे डिस्पोज हो जाऊ या चाहउछन ठीक अछि ए कॉपी टा रखी हबो अपन पाखरे एक्स्ट्रा कॉपी अछि 39 लिखंतु मिस्टर सायंतन पंडा फॉर द पिटिशनर रेस्पोंडेंट डाटा बंद रहेला रेस्पोंडेंट ब्लैंक अपोजिट पार्टी ब्लैंक रहेला ना the matter is mentioned though it could not reach due to paucity of time stuff it is submitted by the London Council for the petitioner that CP number 157 of 2024 filed by the petitioner herein under section 11 and 12 read with section 5 of the Hindu Marriage Act 1955 has been allowed by judgment dated 17/12/2025 copy of the said judgment is filed along with memo of fate The memo with copy of the judgment is taken on record. Scanned copy be updated. Para. Though the opposite party is not present before this court, but in view of the disposal of the CP, no order is passed that which would prejudice the opposite party. Para. The writ application was filed with a prayer to set aside order dated 21.06.2025, 21.06.2025 in IA 1 of 2025, arising out of the CP number 157 of 2024. The IA was filed invoking the provision of section 24 of the Hindu Marriage Act, seeking maintenance pendente light, wherein rupees 5,000 was per month was directed to be paid by the learned judge, Family Court, Noyagarh, by order dated 21/6/2025. In view of the disposal of the CP, the order passed under section 24 merges with the final judgment by which the suit was dismissed. Therefore, when ଆପଣଙ୍କ ସୁଟ୍ ଡିସମିସ୍ ହେଇଗଲା
ଡିସମିସ୍ ବୋଲି ଲେଖିଛନ୍ତି ବଟ୍ ଆମର ବାହାଘର ହେଇନାହିଁ ବୋଲି ଅର୍ଡର ହେଇଛନ୍ତି ଅର୍ଡର କରିଦେବେ
ଏମିତି କେମିତି କଲେ
ମାନେ ସେକ୍ସନ 11 ଆଉ 12 ରେ null and void ଡିକ୍ଲେୟାର କରିହବନି ବଟ୍ ଇଟ୍ ଇଜ କ୍ଲିୟର ଦ୍ୟାଟ୍ ଦେयर ଇଜ नो
ଡିସମିସ୍ ତ ହେଇଗଲା
ଡିସମିସ୍ ହ୍ୱାଟ
ଡିସମିସ୍ ହେଇଗଲା ଆପଣ ତ ହାରିଗଲେ ଫେର ଏଠି କେମିତି ଆସୁଛନ୍ତି
ନାଇଁ
ହାରି ଫାଇଲ କରିବେ ନା ଆଉ
ହାରିନୁ ଆମେ ସେ ଅଲରେଡି କହିଛନ୍ତି ତା
କୋଉ ପାରାଗ୍ରାଫରେ କହିଲେ ଆପଣ ଗୋଟେ ନୂଆ ଥିଓରି ପରେ କଲେଣି ଆଜି ତ ଲାଗୁଛି ଯେ ଆଜି ପୁରା ଚାଲିବ ନୂଆ ନୂଆ ଥିଓରି
ପାରା 19 in the instant case the above parameter fulfilling the mandatory requirement of valid marriage have not been adhered by the parties in the circumstances the marriage date 1/3/2020 between the parties is not a Hindu marriage having regard to the provision of
ସେଟା ଆପଣ ପଚାରିଥିଲେ ଆଜ୍ଞା କୋଉ ପ୍ରୋଭିଜନ ରେ ଆପଣଙ୍କ ଫାଇଲ ହେଇଛି ଏଥିପାଇଁ ଡିଭି ଆକ୍ଟ ଅଛି 125 ବି ହେଇପାରିବ but 24 of course your point is 24 କଣ ଲେଖିଲେ फाइनल जजमेंट को स्टॉप कर दियो The learned counsel for the petitioner refers to paragraph 19 of the judgment. Paragraph 19 टा कोट कर दे सेटा एबे से दो चोद देता एबे जोड़ा दे paragraph 19 copy of which is filed in court today. In view of the above, as far as the order passed by the learned judge, Family Court, dated 21/6/2025, no more survives, and the writ application is accordingly disposed of. However, the opposite party, however, the rights of the parties to challenge the order, there is a judgment dated 17/12/2025 would survive. से लास्ट लाइन टा मु खाली लिखुची देखिबा आई मे डिलीट दैट लाइन एटा रखिबे 39 yes any other mention ଆପଣଙ୍କ matter ଆପଣଙ୍କର କୋଉଟା sir?
I don't 28 ଥିଲା
28 sir 28 after notice
with
matter
the commencing from 20.
ହଁ ହେଇଯିବ ଆପଣ ଆସନ୍ତୁ ଦିଟା ମେମୋ ସାର୍ ଦେବେ ସେଟା ଗୋଟେ ଜଏଣ୍ଟ ମେମୋ କଲେ ତ ଦିଟି ଯାକ ତାଙ୍କୁ କହିଲେନି ସେ ପଳେଇଲେ ଛାଡି ଦଉଛନ୍ତି ମୁଁ କହିଲେ ଆପଣ ଜଏଣ୍ଟ ମେମୋ କରିକି ଦେବେ କାରଣ ସେଟା ତାଙ୍କର ଯୋଉ ପିଟିସନ ଟା ଅଛି ଟ୍ରାନ୍ସଫର ପାଇଁ ସେଇଟା ଦରକାର ନାହିଁ ବୋଲି ସେ ପଳେଇଲେ ତାକୁ ଡାକନ୍ତୁ सब ठीक अच्छे नहीं तो पाइले आउथरे दस्तखत कर देबे सेटा अपन टेबल ऊपर रखो ये श्योर मैटर
ट्रांसफर ताको क्रियाटा एलाउ
तो सर जानिले बोली तार पर्पस अछि तार क्रिया कारण जे मेनी टाइम्स द मैटर इज नॉट प्रोग्रेसिंग देयर जानछन जेटी पेंडिंग अछि से मैटर से पड़ी के रहउछि देयर आर सो मेनी आई मीन नुआंसेस टू इट एनीवे लीव इट ठीक अछि I'll take care of that. This is the Dividago Didio. Item 11 Lepanto. Mr. Manoj, Mr. KK Patel.
Yes, ma'am.
You not to make see to page 21 annexure 3. That will be clear.
No, he actually, Mr. Since you are not there, you can ask Mr. Sethi and Mr. He never said that I have. He said it is a oral threat. I asked that by which order. I asked him that I cannot pass any order. But your point, he has now understood. That in view of Annexure 3,
yes,
the authorities have to wait to give full effect to Annexure 3.
Yes.
Is Series Chari.
Yes.
That is your submission. He concedes there.
Yes. And he has also filed a representation.
Correct.
That can be
correct.
My apprehension that before expiring of the extended period, if they will take any
apprehension has
apprehension normally the case as again Mr. Lenka habani teno apu semti au kala kemti ho
apprehension Government of India simultaneously state government has both agreed to allow them. This is for KMS 2425.
Yes. Mr. KK Patel for the petitioner, Mr. DN Lenka AGA for the opposite party.
Not all the opposite party, madam.
1 3 4 and 5.
Yes.
Though the matter is listed for fresh admission, stuff. In view of the order that is to be passed, the other opposite parties are not noticed. Both of you take your seat. I have to take some minutes to dictate this. Connect. Are not noticed, and the order shall not prejudice the opposite parties. Corporation of 2 and 6. The petitioner is a custom miller of rice.
Yes, ma'am.
Is a custom miller of rice.
In the name of
He has approached this court apprehending invocation of bank guarantee that was furnished before कहाँ पाखरे furnish कले collector का पाखरे
No, my lord, civil supply office. OP.
अपन from tebe
Hello?
CSO Balangir
Yes, CSO Balangir.
that was furnished before the OP number 4
Under
civil supply officer Balangir. The bank guarantee being furnished through the Bank of India, Patanagarh, OP6. Upon advance copy served, the learned AGA appears and waives notice on behalf of the opposite parties 1, 3, 4 and 5. It is submitted by the learned AGA that as such there is no threat as contemplated in the writ petition. It is submitted by the learned counsel for the petitioner that the अपन OP6 visit कले ना कि visit करते ले कले अपन डरी गले बहुत
squad
बेरो सेंती की
squad constituted by OP4.
That the OP number 4, the squad constituted by OP number 4 has visited the premises
For physical
verification, for which the petitioner apprehends coercive action. Take yours. The learned AG refers to the annexer 3.
Food and supplies consumer.
Page कितने कहना?
21 man.
Page 21. Refers to the annexer 3 to the writ application. That is notification, the office letter issued by the government, the Department of Food Supplies and Consumer Welfare, Government of Odisha, to all collectors, dated 31/12/2025. The said letter is scanned and reproduced here. Para. The Learned Counsel for the petitioner as well as the Learned AG converge on the aspect that the said letter has been issued to all concerned, particularly the civil supply officers throughout the state.
All collectors.
To all collectors.
Yes.
A Managing Director, Odisha Civil Supply Corporation, and the civil supplies officers. Page 22, Raj, all some to judge. Perusal of the said letter indicates that period of milling of paddy and delivery of custom milled rice into bracket CMR for the Kharif main season, 2024-2025 has been extended to 30.04.2026. Pursuant to the said letter, the petitioner has also filed an representation dated 31/2026 before the opposite party number 3 collector, which seems to be in the form of which seems to be in the nature of a abundant caution. Collector कौन है government ऊपर है अपन भी कौन कहते abundant caution para. This court also takes note of the notification issued by the Government of India, Ministry of Consumer Affairs, Food and Public Distribution, dated 31/12/2025, which is scanned and reproduced herein. In view of the annexer 3 and 4,
2 and 3.
Annexers 2 and 3. Page mark.
Annexer 3 only. The Government of India letter to
BC region. Annexer 3 series. In view of the Annexer 3 series. और एमती कोन annexer करछंती सबके एमती करा जाय नै आपण गवर्नमेंट गोटे तांकर गोटे आंकर गोटे in view of the Annexer 3 into bracket series, that is letter dated 31/12/2025 issued by the Government of Odisha and 31/12/2025 issued by the Government of India. It is observed that the authorities shall abide by the said letters extending the last date of delivery of CMR into the central pool up to 30.04/2026. Accordingly, the authorities shall not take any coercive action during the extended date till 30/4/2026.
Regarding
The petitioner shall also abide by all the conditions as imposed in those letters.
Yes.
That has to be meant for the custom millers. Yes. The petition is disposed of. Yes,
collector କୁ ସେ ଦେଇଛନ୍ତି ପେଣ୍ଡିଂ ଅଛି collector କୁ କରିଛନ୍ତି।
ସେଇଟା actually collector କୁ ସେ collector କୁ ବହୁତ ଡରନ୍ତି। ତ କଣ କରାଯିବ?
ଗଭର୍ଣ୍ଣମେଣ୍ଟ ବି
ଏତେ ଡରୁନାହାନ୍ତି।
ଗଭର୍ଣ୍ଣମେଣ୍ଟ ବି collector କୁ
କଲେକ୍ଟର ଆପଣ ସିଏସଓ ମନା କଲେ 22 ରେ ସିଏସଓ କୁ ପଠା ହେଇଛି। ସମସ୍ତଙ୍କୁ ପଠା ହେଇଛି।
କାହିଁକି
କାହିଁକି ଶୁଣନ୍ତୁ ସିଏସଓ ତାଙ୍କ ଗୋଦାମରେ ଯେ ବୁଲୁଛନ୍ତି କାହିଁ ବୁଲୁଛନ୍ତି ସେଟା ଆପଣ ପଚାରିକି ବୁଝିବେ
ବୁଝିବେ ବୋଲି ମେମୋରେ
ସେଟା ଏଠି ଡିସ୍କସନ କରିବାନି। 31/12 ଲେଟର ଆସିଲା ପରେ ସିଏସଓ କୁ ଟିମ୍ ଯାଇ କାହିଁ ବୁଲୁଛନ୍ତି ସେ ମିଲ୍ ଭିତରେ?
ବିକଜ
30/4 ବୁଲିବେ ନା।
Annexure 3 itself states.
Annexure 3 କଣ states? ବୁଲିବେ ବୋଲି।
Requested to kindly take immediate step to furnish the data relating to procurement and same delivery.
ଠିକ ଅଛି ତା ବୁଲିବା ପାଇଁ କୁହାଯାଇଛି ସେ ବୁଲିବେ ଆଉ କଣ?
So,
but exact reason should not be discussed here. 30/4 ରେ ତ ଅର୍ଡର ହେଲା ଆପଣ କହିଦେଲେ 31/12 ରେ 30/4 ଏକ୍ସଟେଣ୍ଡ ହେଇଗଲା। ସେ ତାପରେ ଯାଇକି I hope what he is saying you can get it. He said that they have to make a survey not because seizing your property or revoking your
survey କେତେ ଅଛି ଏମାନେ କଣ କରୁଛନ୍ତି ଆଜ୍ଞା ଚାଷୀଙ୍କ ପାଖରୁ ଅଳ୍ପ ଦାମରେ ନେଇ ଆସିକି
ଆପଣ କି ମୁଁ ଆମେ ସେଟା ସେ ଜାଗାକୁ ଯାଇପାରିବନି। will be confined to our own jurisdiction. Yes. 29 ଦିଟା ଫାଇଲ ଲଗେଇବେ ନା 29 କହିଲି ପରା ଆପଣ ଡେରି କରନ୍ତୁନି। Already you have overshot the times. Thank you.